And we are going to get to our standard offer to purchase and contract today. A few more things to talk about before we get there, though. Where we left each other Tuesday, we had defined this magic moment in time when it goes from being an offer to a contract. And as agents, we need to know. We don't need to guess. We don't need to assume. We don't need to think. We need to know when we are under contract because we're going to let our buyers and sellers know the good news. And we need to make sure that when we speak, we're very clear. Be very clear. Words matter. You either have an offer or a contract. And we need to know when that changes hands. We need to know when that offer throws a negotiation, still bouncing back and forth with counter offers, until we have this magic moment in time where we are officially under contract. So the first off, and we're going to dig a little deeper in this today. So we're going to talk about this communication, and we're going to bring agents into the throes as well. How does our roles affect this offer and acceptance? So before we build on it, let's just revisit where we left off. And we have this magic moment in time. We must have two things happen. First off, when the offeror makes an offer to the offeree, what are the offeree's three choices? One of them is right there in front of you. So that's the easy one. They can accept it, but they have two other choices, right? They could also reject it or counter it. Let's all say that together, please. This is important. Nod, nod, wink, wink. When an offeree receives an offer, they have three choices. They can accept it, reject it, or counter it. As we said, if they're accepting, they're agreeing to all of the terms exactly how they are. Any change, I don't care how small and insignificant it could seem. You know, we could have something in there. I could offer to buy your house for $199,999, and you counter at 200. Is $199,999 and 200 the same thing? No, we got to negotiate. We got to work out that dollar difference. Everybody with me? All of the terms exactly the same. Your other option or another option is to reject it. If you reject it, you've killed it. It's dead on the table. Once an offer has been rejected, there is no reviving it. You cannot bring back a rejected offer. That's what it means to be dead on the table. And then our third option is to counteroffer. And with a counteroffer, the roles reverse. The offeror becomes the offeree. The new offeree now has three choices. They can accept it, reject it, or counter it. So typically, a traditional transaction, we're going to have a couple counters, which means we're going to throw that ball back and forth a couple times, right? Hopefully getting the parties a little closer and a little closer together. At some point, we're going to reach a point where we're so close that somebody's either got to accept it or reject it. And in order for this offer to become a contract, we must have three things. The last offeree has to accept it. For your exams, when you see that the offeree has accepted it, know that it's been signed. You don't have to ask yourself, when you see the word acceptance, you don't have to ask yourself, I wonder if this has been signed or not. When you see the word, thumbs up, please. When you see that word accept, you know that it's been signed. In the real world, I need you to verify that it's been signed. And we'll get to that in post-licensing. But for right now, we're going to know acceptance means that it's been signed, step one. And then step two, we need communication of acceptance to cross the line and go back to the offeror. So looking at our picture, the last offeree accepts, which means they have signed, and then communication of acceptance has got to cross the line. Please note what it is we are communicating. we are communicating the fact that it's been signed. I may not get you the signed document until later today. That's not what I'm talking about. I'm not talking about delivery of the signed contract. I'm talking about communicating the fact that it's been signed. And the different methods of how we can communicate acceptance comes down to agreement of the parties. And I'm going to get to that in just a second. Communication of acceptance basically can happen in any form that the parties agree to. If they agree to text, then communication of acceptance can happen in a text or an email or a phone call, whatever it is that they agree to. Again, you guys, we're not saying I'm delivering you the contract. What I'm saying is I'm communicating to the other side, to the offeror, that their offer has been accepted. Their offer has been signed. So before we build on this, let me just pause here. We're going to talk about communication. We're going to bring agents into the throw, brokers into the throws. What questions do I have so far just on this screen before we build on it? Let's build. Let's throw agents into the mix. When buyers and sellers hire brokers, buyers and sellers hire firms and bring brokers into it. When it comes to communication of acceptance of an offer, talking to me, communicating to me is just as good as communicating to my buyer and seller. Once you tell me that it's been accepted, congratulations, we're under contract. It doesn't matter that I haven't called my guys yet. I need to the next step, right? But communicating to me is exact same as communicating directly to our buyers and sellers. So now back to our picture here, let's throw some brokers into the mix. So now you have buyers and sellers that are represented. They have brokers standing with them on their side of the contract communication wall. So you are a buyer's agent, a selling agent, and you are out showing property to your buyer. Your buyer walks in the front door of a home and says, this is it. This is my dream home. Let's write it up. So you run to your laptop, your device, fill in the blanks of the offer to purchase and contract per your buyer's instructions. You have your buyer sign the offer. Offerors need to sign the offer to show that the offer is legit, to show that they're serious. I mean, put yourself in the offeree's shoes. If you received an unsigned offer, how serious would you take it? Not much, right? So the offeror will sign. The buyer's agent is going to present the offer to the listing agent. So the buyer's agent is going to reach out to the listing agent and say, hey, we got an offer. This is what's up. This is what you need to know. We look forward to hearing back to you once you've discussed it with your seller. Listing agent calls a seller, goes over the terms. Listing agent tells the seller, you got three choices. You can accept it, reject it, or counter. So the listing agent and the seller discuss, they go over their options. If we were to counter, what would we counter? Yada, yada, yada. The seller says, this offer looks really good. I will accept it. Acceptance means what? You could actually show, yeah, air sign it. Acceptance means that it has been signed. So we have the offeror has signed it, and now the offeree has signed it. Are we under contract yet? Not yet. The offeree just signed it. Does the offeror know that it's been signed? And that's where that second step is. The person making the offer has got to know that their offer has been signed. So the seller calls their agent and says, I have signed it. Did that communication cross the line? When the seller called their agent, did it cross the line? Shake your head, yes or no. Did it cross the line? No. So are we under contract? No. Listing agent calls the selling agent. Did communication cross the line? Congratulations, folks. We are under contract. Good job. As the selling agent, what's going to be their very next step? What's the next thing they need to do? The courtesy. We would venture a guess. It's signed. We've communicated. We haven't talked about earnest money yet. Once the listing agent calls the selling agent, we're under contract. The next thing the selling agent needs to do is call their buyer and let their buyer know the good news. And when I call my buyer, I'm not saying, are you sure you still want it? When I call my buyer, I'm saying, congratulations, you're under contract because we have had acceptance and we have had communication of acceptance. Communicating to the broker is just as good when we are negotiating offers, when we are forming contracts. Communicating with the broker is just as good as communicating with the client. The different methods of communication, and again, like we said, communication of acceptance can happen in any method as long as the parties agree. And we do have a place in our offer to purchase and contract for the parties to specify how they want to be communicated with. So we got traditional methods of communication. You can pick up the phone and call them and say, my guys have accepted. Congratulations, we're under contract. I'm in the car, I'm on the road. As soon as I get back to the office, I'll email you the signed contract. But remember, you guys, we're not talking about delivery of the document. We are talking about communicating the fact that it has been signed. So you can pick up the phone, say, yep, I'm in the car, I'm out and about. As soon as I get back to my office, I will email it to you, but just want to let you know that my guys have accepted your offer. You could communicate acceptance via fax if the parties agree. You could go old school and drop that in the mail. You could go old school or drop that in the mail. There is, I just want to point it out in your books on page 291. If you're going to use the USPS, we follow the mailbox rule. And I know it's 2024. I'm aware of that. We don't use the USPS anymore as much anymore. But I also know that not everybody has an email. Not everybody trusts electronic methods. So you very well may come across a client that won't do stuff. So we got to step back into old school, right? We may have to drop something into the mail. So the mailbox rule, as long as we still have the USPS, the mailbox rule is going to apply. The mailbox rule says once the signed contract has been placed in the mailbox, communication of acceptance has happened. It doesn't matter that the recipient won't receive it for 2 or 5 days later. Once we have that signed, accepted document placed in the mailbox, communication of acceptance has happened. The mailbox rule only applies to contract formation. It doesn't apply to negotiations. It doesn't apply to terminating the contract. It doesn't apply to delivering monies or funds. The mailbox rule only applies with communicating acceptance of a contract. Some more modern methods of communicating is our e-world. So again, if the parties agree, we can communicate acceptance via email, e-signatures, of course, text messages, etc. I'm reluctant to say pick up the phone and call, because then you don't have your documentation. And what do we want to document? Everything. I mean, you could show, yeah, I called you at 2 o'clock today. What does that prove? At least if you have a text, if you have an email, does that make sense? At least if you have something, you can say, I texted you at 2 o'clock today and said, my guys have accepted. I will send you the signed document just as soon as I. So communication of acceptance, any method that the parties agree to. And of course, this list isn't inclusive. You could agree to hand deliver the signed contract. You could agree to do courier pigeon. Any method of communication of acceptance is okay, as long as the parties agree. And again, we have a place in our contract to specify how we want to be notified, how we want that communication of acceptance. So for example, an owner offers to sell to a prospective buyer. The offer states that the acceptance must be made by email message only. Instead, the buyer leaves a phone message informing the seller that he accepted and signed the offer. Are we under contract? No, because phone message wasn't the agreed upon method of communicating acceptance. How's the only way that we could communicate acceptance in this example is via email, because that was what the parties want. The parties have got to agree to it. And when you throw agents into the mix, we'll handle that. We'll handle the communication. I think I've mentioned, I don't want my buyers and sellers talking to each other. Let the agents talk to each other on behalf of their buyers and sellers. I don't want my buyers and sellers saying something and accidentally committing themselves to something. So once agents are involved, that's how the communication's going down. What questions do I have? That magic moment in time when it goes from being an offer to a contract. Two things for your exams. I think you should draw the contract formation one. Because you are going to have to see when this offer becomes a contract. Also, these test questions, you guys, are like this long. You're going to have some counter offers. They're going to go back and forth. And I need you to see whenever we have a counter, those roles reverse. The offeror becomes the offeree becomes the offeror. We need to see who is the current offeror, who is the current offeree. Because wherever we end in this communication, we need to know who the offeree is that needs to accept it and the offeror who needs to communicate acceptance. So I suggest you guys draw it out, walk it back and forth so you can see we have acceptance of the offeree, and then communication of acceptance has crossed the line. If agents aren't involved, we still need communication of acceptance to cross the line. The other thing for your exam, when it comes to communication of acceptance, they may give you several different methods. I only need communication of acceptance to cross the line once. Anything after that is a follow-up. So it might be that I communicate acceptance, I send you a text, I follow it up with a voicemail, and then I later email you. Which method put us under contract? Which one put us under contract? The first time that communication crossed the line was number one, was the text. The voicemail and the email are follow-up. These are called distractors. So I need you to see. I need you to see when the first time that communication of acceptance crosses the line, because congratulations, folks, that's when we are under contract. Both of your exams, you get scratch paper. Utilize your scratch paper and draw it out. It's easier to see. I also want you guys remember our offer or an offeree. I think in some cases it's way too easy on your test to say buyer and seller. So we need to know who that offeree is, the giver or the receivee of the offer, and the offer or is the giver of the offer. Yeah, Victoria.
So I have a question. So once communication has crossed the line, then you're under contract. So let's say if you're the seller, the offerer, and let's say your broker didn't see the email that you sent that night. So then let's say the seller wants a counter offer. It doesn't matter if the broker's seeing that message or not, once it crossed the line and and acceptance has been
That's right. That's a great
communicated,
point,
then you're under
Victoria.
contract.
Yes, because back to our example here, you may send me a text right now, say my guys have signed, but I'm busy till 1 o'clock. I don't look at my phone much until 1 o'clock today, right? So I may not see it until 1:05. But we went under contract when you texted me at 9:22. And that's why I like that document. Me personally, that's an in practice thing, you guys, but I like that documentation versus, but I called you. You know, if you have to call somebody, make sure you leave a message. And then even then, it's really easy for them to erase it, right? And you'd still just have your documentation was that you made the call. So you know, you guys know I preach this document everything thing. And I'm a big fan of text or email. So we have that documentation. If communication of acceptance is via email or text, communication of acceptance has happened once it hits the recipient's inbox. Not when you open it, not when I send it, when it hits your inbox. Thank you for that, Victoria. Guys, there was an article that came out from the Real Estate Commission like 2-3 weeks ago that there were a lot of complaints by consumers that thought they were under contract because the words their agents used led them to believe that they were under contract. Put pre-licensing aside for a second. Real world stuff. If you got verbal acceptance, you have nothing. You have nothing. We're not official until it's been signed. So I could call you or text you and I could say, my guys are good with these terms. They're going to sign. Is going to sign and have signed two different things. Everybody hear that difference? You're going to sign or you have signed. It doesn't matter until you have signed. But what happens is they call and say, my guys are going to sign. The agent calls their client and says, hey, you're under contract. And then before they can get signed, another offer, a better offer, comes swooping in. And guess what? That verbal acceptance is not going to get signed. And now you got to call your guys back and say, I know I said we were under contract, but words matter. I need you to be clear. I need you to be sure. They kind of, that article a couple weeks ago, because we used to say stuff like, you got yourself a deal. They're kind of cracking down on that because, you know, you can't use those unless, in fact, you have yourself a deal. If you got verbal, you have absolutely nothing. If you have written, now you got yourself a deal. Words matter. Anything else? We'll see this again. We got some examples later in this unit, which will be a good time to revisit it. Again, draw the line and then write down the methods of communication, the methods that they cross the line. Again, you got to read these questions. You got to dissect these questions because they're going to say something like, okay, so the buyer was the last offeree, so they accepted. And then the buyer called their broker. Did that communication cross the line? But we tend to think, because we had a form of communication, we had a phone call. So we tend to jump to conclusions and say, oh, somebody got a phone call, so we're under contract. This is where I need you guys to see the communication. So when the buyer calls their broker, did that arrow cross our communication line? No. The agent calls the agent. Now did that, and I need you guys to see that arrow cross, not on the same side. Communication of acceptance has to cross the line. Big fan of pictures. I'm a big fan of the contract communication wall. I'm trying to think of a better name for that, but it gets the point across. Yes, contract communication wall. Some of these longer test questions, you guys have the ability to bookmark a question, skip a question to come back to it later. I recommend some of these questions that are like this long and are going to take you time, bookmark them and save them to the end. Save all the math to the very end. Save all these longer questions like these, for example, so you know how much time you have in the end. We will talk about test taking strategies. That's just one. So the last little piece is terminating an offer. Please note that word says offer. We've talked about how we can terminate or discharge contracts. This is specifically terminating an offer. So as we've been saying, a rejection and a counter offer terminates an offer. A counter offer is a rejection with a but. So with that being said, shake your head yes or no. Once you've countered something, can you later go back and accept the original offer? No, because once you've countered it, you've killed the original offer. You can't go back. You cannot go back. Once you've countered it or rejected it, it's done. It's terminated. If the offeree fails to accept within a prescribed time, you can put an expiration date. The offeror can put an expiration date on their offer. So they have the option, if they wish, they could say this offer is good until 5 p.m. on Friday, April 19th. If we don't have acceptance by then, the offer is terminated. It is dead on the table. The offeror can also terminate within a reasonable amount of time. What's a reasonable amount of time? That's going to depend on the offeror. How long do they want to wait? This is what I do know. Prior to acceptance, the offeror, and this is important, the offeror is free to revoke their offer at any time prior to acceptance. If you revoke your offer, you take it back. You say, never mind, just kidding. The offeror is free to revoke their offer at any time prior to acceptance, even if you put an expiration date on it. So if you say this offer is good until, what did I just say, April 19th at 5 p.m., and you go out this afternoon and see something you like better, you can revoke your offer. You can take it back. Death of either party will terminate the offer. Remember, we're talking about the sales contract, so the parties are the buyers and the sellers. Death of either party will terminate the offer. Fun fact, death is not an out once we're under contract. Death is only an out when we're negotiating the offer. Once we're under contract, the people's terms, what they want, are clear because we have a signed contract indicating their wish to buy or sell. Our contract actually says that this contract is binding to the parties and their heirs. When do heirs kick in? The individual passes away. So if a buyer or seller pass away once we're under contract, the contract lives on. What if the heirs don't buy? What if they can't or don't, I shouldn't say buy, what if they can't or don't follow through with the terms of the contract? then they suffer the consequences of breach that are spelled out in the contract. Once a party passes away, their heirs take over their obligations as if they were that party. So death is only an out when we're negotiating the offer. Once we're under contract, death of either party is not an out. If they terminate or their heirs terminate, they'll suffer those consequences of breach. So we're just about to talk about our standard offer to purchase and contract. But before we look at the actual document, I want to talk about some things. I'm going to go off book for a bit. And I want to talk about some things that we're going to meet in the contract, we're going to see in the contract. But my experience has proven that if we can have a conversation about it up front and then talk about it again in the contract, and then you guys review it, remember that power of repetition, hearing something over and over and over again. So I'm going to introduce you to some concepts that we're going to see in our contract, some things that have tended to be confusing at first, especially when you're new and getting used to it. Can I repeat prior to acceptance? The offeror is free to revoke their offer at any time prior to acceptance. The offeror is free to revoke their offer at any time prior to acceptance. So let's go off book. First thing, one thing our offer to purchase and contract provides us, standard form 2T provides us, is guidelines for completing the form. We mentioned this when we looked at our agency agreements. Your more commonly used forms, maybe more complex forms, the forms committee provides us guidelines for completing. And specifically within the guidelines for completing, they give us just some guidelines to make life a little easier. One recommendation we have is to type if at all possible. Again, it's 2024. We have a means, we have interactive documents, e-documents. You can type right on them, fill in the blanks. If it's not possible to type, hey, I get it. Life happens sometimes. And there's stories of agents writing offers on the trunk of their car in the Bojangles parking lot. So I get it. When the buyer says, let's write it up, sometimes you got to do what you got to do right then and there, right? So if you can't type, if typing isn't possible, make sure you're writing legibly in ink. Do not write a legally binding document in purple crayon. So we're going to write legibly so everybody knows what it says. Some of us can do that better than others. And we want to do that in ink where it's binding. Another guideline, and this one's important, you guys, we're never going to leave a blank blank. Anytime we have a blank in the contract, we're going to put something in it, even if it applies to this transaction or not. If you have a blank that doesn't apply, then you put N-A for not applicable. If the blank is asking for a money figure and it doesn't apply, you put in 0. There's 2 reasons why we're never going to leave a blank blank. One, when I present the offer, I don't want the other side to think that I accidentally forgot to fill something in that blank. I don't want them to think that I'm presenting them an incomplete offer. The second reason, I don't want the other side to slip something in to a blank without us knowing about it. So how do we protect all parties? Fill in all the blanks. There's a blank there for a reason. We're getting ready to see all those blanks, our roles with the offer to purchase and contract. Be precise. Again, we mentioned this the other day. We can't use our broker vernacular. We can't talk about acronyms and our broker jargon, and we're dealing this for the consumer. So we need to make sure that the consumer understands their legally binding contract. All changes, additions, deletions need to be acknowledged by both parties. Maybe that's on the document itself. Maybe it's an agreement via an email or text. Maybe we're going to do an amendment and make that change, but we need it somehow documented and acknowledged by all parties. And then part of our big responsibility as brokers is to review the contract provisions with the parties, help them understand what it is they're offering, help them understand what it is that they're accepting. I'm going to tell you guys something right now. For the most part, buyers and sellers are not reading the offer to purchase and contract. They're discussing it with you. They're discussing the terms with you. But if you hand an offer to purchase and contract to a buyer or seller, for the most part, you come across a reader, but for the most part, they're not reading this document that is legally binding them to another person because they trust us and they trust that we have their best interest. With that being said, because we know most of them aren't reading, we still need to have these conversations. We need to still make sure that they understand the different contract provisions. Today will be your very first day of exposure of the offer to purchase a contract of many. We need to be knowledgeable with this document. We need to know what's in it so we can have these conversations. So I want to talk about some common provisions we're going to find in our offer to purchase and contract. Again, things that are just, they may be new concepts to you. So instead of just dumping you into the contract, I just want to talk about them and expose them to you first. So when we get to the contract, they might be start clicking a little bit. And in particular, and some of you know these things, and that's great. But in particular, the things that I want to talk about, the common provisions I want to introduce you to before we get to our contract is something called a due diligence fee, a due diligence period, and an earnest money deposit. Please take a second and jot this down so you have it for reference, because my future slides refer to the DDF, the DDP, and the EMD. So what am I talking about with DDP? I'm talking about a due diligence period, defining each of these in just a second, and seeing them defined in our offer to purchase and contract when we get there as well. This would best be one of these discussions. If you give me just a minute, I might answer your question. And of course, I'll have time available afterwards for questions. But give me just a second as we talk about DDF, DDP, EMD. Everybody got my acronyms jotted down? We know what I speak of? Teaching you guys how to speak broker. I don't run around talking about due diligence fee. You know when I look at my agents and say, you got that DDF? So teaching you guys to speak broker. All right, so what is all this saying? What's all this mean? Typically speaking, not always, there are exceptions to these rules, but typically speaking, a deposit is refundable. A fee, typically speaking, is non-refundable. So yes or no, due diligence fee. If you pay a DDF, what do you think? Typically speaking, will you get that back? Thumbs up for yes, thumbs down for no. Will you get it back? Typically speaking, no. There are some exceptions. Earnest money deposit. Typically speaking, will you get it back? Maybe. That one is, it depends. And we're talking about that. Let's first talk about this due diligence fee. The due diligence fee is paid at the time of contract formation. The due diligence fee is paid directly from the buyer to the seller. Once that communication of acceptance crosses the line, the buyer now owes the seller some money. And the money that that buyer owes the seller is referred to as the due diligence fee, the DDF. Why in the world is the buyer paying the seller at the time of contract formation? During the buyer's due diligence period, the buyer has the right to terminate for any reason or no reason at all. The due diligence period is the buyer's opportunity to learn as much about the property as they possibly can and decide, now knowing what I know, do I want to proceed with and purchase, or do I want to terminate? If the buyer terminates during the due diligence period, they are not in breach because the buyer paid for that right. The seller accepted payment for the right, giving the buyer the right to terminate. The due diligence fee is completely negotiable. There is no formula, and hey, I get it. New agents are looking for a formula. Market is going to drive the due diligence fee, market conditions, this crazy seller's market we're coming out of. Y'all, I was hearing of due diligence fees of 5 digits. As we get back into a buyer's market, we might start seeing due diligence fees of 3 digits. So market absolutely can drive the amount. Bottom line, it's completely negotiable. The real estate commission says, they're so helpful. They say, whatever the buyer's willing to offer and the seller is willing to accept. So if the buyer offers $1 and the seller accepts $1, a contract has been formed with the due diligence fee of $1. Totally and completely negotiable. The only thing that the buyer is paying for is their right to terminate during their due diligence period. So what if the buyer terminates during the due diligence period? They choose to terminate. They choose to exercise their right to terminate. Shake your head, yes or no. Are they going to get their fee back? What do we just say about fees? Generally speaking, fees are not refundable. So if the buyer exercises their right to terminate within the due diligence, they're not going to get their money back. But guess what? The seller can't go after them. Maybe in a court of law, for example, the buyer's not in breach. We remember caveat emptor. Buyer beware. I think the due diligence period is the answer to caveat emptor. The seller doesn't have to disclose. They don't have to do anything but sell their house, pretty much. Let's give the buyer an opportunity. If the onus to learn about the property is on the buyer, let's give them that opportunity. And can we all agree not much in life is free? And that would include the opportunity to decide if you want to buy or not. That's what you're paying for. That's what the buyer's paying for, is that right to terminate. So just introducing you to, let me also go ahead and introduce you to the earnest money deposit. When we have contract formation, the earnest money deposit is paid by the buyer, and it's going to go to an escrow agent. It's going to sit in a trust account. The seller never touches the earnest money deposit. An escrow agent is either going to be the real estate firm, or it's going to be our closing attorney. You got to have a trust account or an escrow account in order to be an escrow agent. We're going to talk about that trust account and license law and commission rule. This also is a negotiable item. Whatever the buyer's willing to offer and the seller's willing to accept. The whole point of the earnest money deposit is to show the seller that the buyer's serious. It's a serious buyer. Money talks. I don't know anything that talks louder than money, right? How do you show somebody you really, really want to buy their house? Show them some money. Be willing to put some money down. Be willing to have some skin in this game. And that is called the earnest money deposit. The earnest money deposit. So your buyer goes under contract. If we go under contract, when did we just go under, Victoria? About 9:22 this morning. My buyer now has to go out, get me 2 checks. As soon as we are under contract, I need to get from my buyer an earnest money deposit and a due diligence fee The due diligence fee will be delivered straight to the seller. The earnest money deposit will go to the escrow agent. Again, we're just showing the buyer's good faith. If we think this through, if you offer to buy my house today and I agree and we go under contract, don't I got to find somewhere else to live? You're not trying to find a roommate, are you? You want my home. And I got to find somewhere to live, which means I have to make an offer on a property or sign a lease. And before I make these kinds of commitments, I want to know that you're legit. And how do I know you're legit? Because you're willing to put up some earnest money deposit. So, no, Lauren, that's not the only difference. One difference, yes. So with the earnest money deposit, if the buyer terminates, is the buyer going to get their deposit back? If the buyer terminates, will they get their deposit back? And the answer is, it depends. It depends on where we are in the contract process when the buyer terminates. If the buyer terminates. As we just said, the buyer's not in breach until after our due diligence period. They could terminate at any time during their due diligence period and not be in breach. Why? Because they paid for that right to terminate. You paid somebody for the right to terminate. You terminate, they can't go after you in court. You can't be in breach because they accepted that you have that right. So the buyer's not considered in breach until after our due diligence period. So if the buyer terminates within their due diligence period, they'll get their earnest money back. They're going to lose the due diligence fee. The seller will keep that because you paid for that right. Now you've exercised your right. But if the buyer terminates within the due diligence period, they have exercised their right to terminate, and I will get them their earnest money deposit back. If the buyer terminates for any reason after due diligence, now not only will the seller keep the due diligence fee, but now the seller's getting the earnest money deposit. So is their buyer getting an earnest money deposit back? The answer is, it depends on when they terminate. And they don't all terminate. And we're going to address what happens if we don't terminate in just a second. So if we terminate within due diligence, the buyer will get their earnest money deposit back. They'll lose their due diligence fee. But let's walk this through. You go in to a contract to buy my house where I don't have to disclose. I've done a nice paint job. There's nothing, I got new carpet. I've just come in and redone everything. So everything looks nice and neat and clean. I'm not disclosing because I don't have to as a seller, not as a broker. But as a seller, I don't have to, pretending I'm not a broker. Sorry. I don't have to disclose. The buyer comes in kind of on a wing and a prayer, don't they? They're submitting an offer, a chance to buy your property, and they know absolutely nothing about the property. They have their inspections done. Part of the due diligence period is for the buyer to learn as much about the property as they possibly can. So this is when we're getting inspections done and surveys and the appraisal, and we're trying to get through the loan approval process. We're trying to get all these questions answered. And let's say during the inspection of my house, you find out the roof is shot, it needs to be replaced soon. Roofs aren't cheap, by the way. The crawl space is in really bad shape. It's got moisture and bugs and critters, so you're going to have to deal with that. And the plumbing's not real good, so you're going to have to deal with that. Everybody else hearing dollar signs? You got a decision to make, and you can ask me to do repairs. Do I have to fix anything? Do I have to do repairs as a seller? Nah, I don't have to fix anything. So you say, I would buy your house if you got a new roof. I'm not getting a new roof. If I was going to get a new roof, I'd have gotten a new roof while I owned it, but I'm not, so I'm not. You now have a choice to make. Now knowing what you know, do you want to take on these big commitments of a roof, a crawl space, and plumbing? Or do you want to forfeit your due diligence fee, walk away, and get your earnest money deposit? The whole point of the due diligence period is for the buyer to learn as much about the property as they possibly can to decide, now knowing what I know, do I want to proceed with or terminate this transaction? And again, I always think of the due diligence period. I believe, my opinion, but I believe it was created to counter the caveat emptor thing. If the seller doesn't have to disclose, it's only fair that we give the buyer an opportunity to learn. And that's what the due diligence period is for. Yes, you have to pay for that right to terminate. And if you terminate, you've exercised that right to terminate. If we find out, or if we terminate after the due diligence period, the seller will keep the due diligence fee. And now the seller is going to get the earnest money together. After the due diligence period, the due diligence fee and the earnest money together are the seller's liquidated damages. We talked about liquidated damages in Unit 9. Liquidated damages say these are money damages that we agree to at the time of contract formation. We agree to a due diligence fee. We agree to an earnest money deposit. These two are the seller's liquidated damages in the event of the buyer's breach. Here, that seller breach, I'm talking about that next. Seller's liquidated damages are the seller's sole and exclusive remedy for the buyer's breach. Sole and exclusive remedy for the buyer's breach, which means if the buyer terminates after due diligence, all the seller gets is the due diligence fee and the earnest money deposit. They can't go after the buyer in court for breaching. They can't go after them for more money. That's what liquidated damages are. We agree at the time of contract formation, if you breach, how much am I going to get? So what happens if the seller breaches? If the seller decides they don't want to sell, or the seller's, it's in a state and one of the cousin's husbands isn't willing to sign up and show on closing day to convey that clear marketable title. What if another offer comes in that the seller likes better and they say, well, I want to terminate this one and accept this one? In the event of the seller's breach, the buyer can sue the pants off of them. They can go after them for compensatory damages, Unit 9. They can go after them for specific performance, Unit 9. If the seller breaches, if the seller, for whatever reason, doesn't convey or won't convey clear marketable title, the buyer can go after them in a court of law. Can we all agree that seller breach is much harsher than buyer breach? If the buyer breaches, all the seller gets is due diligence fee and earnest money deposit. If the seller breaches, the buyer can sue. The reason being for that, you guys, that's not on accident. The reason being for this, the seller's the one that initiated this whole thing to begin with by putting a for sale sign in their front yard. Had they not done that, I wouldn't be here. We wouldn't be under contract. If the seller breaches, they are the one that started this thing, and they may suffer some harsher consequences. If your parties breach and they start talking about suing, that's our little red flag to tell them to talk to their attorney. All right, no more doom and gloom. What happens if this thing actually makes it to closing? What happens if nobody terminates and nobody breaches? And lo and behold, we actually make it to closing. We tell our buyers when we go under contract, congratulations, we're under contract. I need you to get me 2 checks, a due diligence fee and an earnest money deposit. Those amounts, if we make it to closing, are going to be credited back to the buyer. So the due diligence fee that they put down, the earnest money deposit that they put down, that's that much less that they have to bring on closing day. It's almost like they've prepaid it if we make it to closing. So tell your buyers, these amounts will be credited back to you at settlement. Think of like a down payment almost if we make it to closing. The other thing that happens at closing with the fees, the due diligence fee will be debited from the seller. So due diligence will be credited back to the buyer. The due diligence fee will be debited from the seller. Remember, the seller never touches the earnest money deposit. So there's nothing to debit from the seller. The earnest money's been hanging out in a trust account during the contract to closing process. We're going to see all of these terms, DDF, EMD, DDP. We're going to see these all spelled out, defined in the contract. So we'll see these again in just a second. But I think it's helpful just to introduce you to them now. I think sometimes we have a hard time with it, especially the due diligence fee. We think, well, the buyer terminated, they're not buying the house. Shouldn't they get that money back? What's that to the seller? How's that protecting the seller whatsoever? We got to protect the contract, has to protect both parties. Listing agents, I'm going to go back just for 1 second. Listing agents, if the due diligence fee comes in and the offer comes in and the buyer's offering $1 for due diligence and they're offering 50 for the earnest money deposit, we need to talk to our sellers about countering. Because if that buyer terminates, if that buyer never shows up on closing day, all the seller gets is that $51. Is that $51 enough for you to terminate the contract you have or terminate the lease that you had to sign? So listing agents, when we talk about explaining the provisions, buyer's agents, we got to explain what the due diligence and earnest money means. Listing agents, we got to make sure our sellers are good with those amounts. I hope we don't terminate. But the truth is sometimes these things terminate and we need to address what happens if they do. Don't assume, don't go on a wing and a prayer. We got to explain all possible situations. What if the buyer terminates during due diligence? What if the buyer terminates after due diligence? What if we make it to closing? What questions do I have? So when we come back from break, we're going to go into our standard offer to purchase and contract. We will be here most of the day. We're going to go through and look at those highlights. By the way, this is a 17-page document. Our offer to purchase and contract is 17 pages now. We're not going through all of it. We're not reading it word for word, but we are looking at the highlights because those are what's in the syllabus. So when we come back, this is where our focus is going to be for the most of the day. So let's go ahead and take 10. We'll get into our contract. Cameras are on. I'm going to take attendance. Oh, Amari, I got you. You're in. All right, so jumping into our standard offer to purchase and contract. Make a note in your book, pages 292, the whole way through 304. 292 to 304. Your book goes over the provisions that we're getting ready to look at in our offer to purchase and contract. So this gives you another explanation of these terms that we're getting ready to look at. As with the agency agreements, the suggestion is that you go through 292 to 304 with the offer to purchase and contract. So when it talks about, for example, terms and definitions, you go through and look at that with the contract, kind of use that as a workbook, if you will, to work through that. In the online learning system, under the Unit 10 material, Unit 10, we have our offer to purchase and contract standard form 2T with highlights. And again, the highlights mean it's mentioned in the syllabus. If it's mentioned in the syllabus, it's a candidate for your exam, for your state exam. We are not going through this thing in depth. We're going to go through and have a basic understanding of what's in here. When you guys come see me in post licensing, we're going to go through this sucker word for word. When you guys are working with buyers and sellers in the real world, you need to be familiar with this. You need to know what's in the offer to purchase and contract. That is the best way that we can protect our buyers and sellers. I want you guys to go ahead and write something down for me. This is for future you. Once you're licensed and you're dealing with buyers and sellers, and the question comes up, what do I do? The answer to that is write it down. What does the contract say? What does the contract say? If it's not in the contract, now we get our BICs and attorneys involved. But the first question you need to ask yourself is, what does the contract say about this? Everybody jot that down for future you. So let's talk about the offer to purchase and contract standard form 2T. First off, note the name. It serves two purposes. It's an offer to purchase, and upon acceptance becomes a contract. Some states just have contracts. Commercial just has contracts. Instead of an offer to purchase, they use a letter of intent. So you write out what you want to offer, and if you agree, then we put it in a contract. North Carolina, we provide you with an offer to purchase, and upon acceptance, we have a legally binding contract. This is for the parties of the buyers and sellers that we'll define in just a second. I do want to point out this first paragraph up here. You have things like buyer that's capitalized, that's not normally capitalized, seller that's not normally capitalized, property. We're not, buyer is not a proper noun in amongst itself. So why is it capitalized? Property isn't a proper noun in amongst itself. So why is it capitalized? If you see something in the contract that is capitalized that wouldn't normally be capitalized, what that's telling us is that means we have defined it somewhere else. So when we're talking about buyer, capital B, we're not just talking about any old buyer out there. We're talking specifically about this buyer. When the contract talks about seller, when the contract talks about property, we're talking specifically about these terms. The first provision of our offer to purchase and contract is terms and definitions. The first 2.5 pages of our contract, we spend just defining things. At a minimum, if you're not going to do anything else with the offer to purchase and contract, at a minimum, read the terms and definitions. I want you to look at the whole thing, but the terms and definitions define the terms and definitions of the contract. And the first thing we need to define is who are the parties to the contract. Not just any seller, not just any buyer, but we need to fill in names. I need full legal names of all parties. Don't throw a Mr. or Mrs. My name is not Mrs. Ryan Campbell. We are not Mr. and Mrs. Ryan Campbell. We are each our own separate entities. You would put Ryan L. Campbell and Julie A. Campbell. We are two different people. If you don't know their full legal name, ask to see their driver's license. Once we've defined who the buyer and the seller are, then we're going to define the property. The property is defined below. So we have a place for a street address, city, zip, county. This is a North Carolina form for a North Carolina property. So they went ahead and filled that in for us. In Unit 4, we talked about the street address. And we talked about how it's an informal reference to a property. When you're conveying property, the street address alone is not enough. The street address is helpful, but it's not enough. We need more. When we're conveying property, which a sales contract is the document used to convey property, in addition to the street address, we also need the legal description, and we're instructed to complete all applicable. So what's the plat reference? What's the subdivision condominium? What's the plat book and page? What's the tax pin? Any other legal description, and then your deed book and page. So by defining the property, we're not just putting in the street address. In addition to the street address, we're going to include the legal description. The next thing we got to define is the purchase price. I'm going to come back to this section in just a second. I want to spend some more time defining things before we talk about what's in this section. Everybody good with that? So let's get a better understanding of what we're looking at, and then we'll come back and revisit this. Kind of a side note, a couple things on the bottom of page 1 of most of our standard forms from NCAR. If you're a member of the National Association of Realtors, your forms can rock that capital R, that Realtor logo. If you're not a member, you can't use these forms. If you're not a member, NCAR does have some forms available, but if you're not a member, you probably need an attorney to draft up a contract for your firm to use. You need an attorney to draft up these templates for your firm to use. But I'm a member, so I can rock these forms. These forms were jointly approved by the North Carolina Association of Realtors, who provides us all of our forms, and the North Carolina Bar Association. I don't know, where do you see that? So these forms are jointly approved. Attorneys wrote these forms. They're legally binding forms written by attorneys. Mari, I'm not sure where you see that. We also have our equal housing opportunity logo, letting consumers know that we are going to respectfully honor fair housing. And then we know this is standard form 2T, and we know when it was last revised. Always make sure you're using the current form. I'll tell you right now, in the e-world we live in today, in the e-world, this is a lot easier to keep up with the current forms as opposed to once upon a time ago when we were all using paper and they'd update the forms and we wouldn't update our files. So e-world, your firm is getting you the current forms. So as long as you're logging into the platform that your firm makes the forms available, you're using the current forms, but it still doesn't hurt to check it. Okay, so still defining things on page 2. This paragraph is addressing what happens if the due diligence fee or the earnest money are late. We'll see when their due dates are in just a second. What happens if they're late, or if those funds are dishonored, which is just a fancy way of saying the check bounced. So if they're late, if they're not delivered on time, or if the funds are dishonored, the seller has to provide the buyer written notice to deliver funds The buyer has one banking day from receiving that written notice to deliver the readily available funds. If the buyer doesn't deliver within that one banking day of written notice, then the seller shall have the right to terminate. So the due diligence fee or the earnest money are late, or those checks bounce, it happens. What do we do? The answer to that is, what does the contract say? The contract tells us how to handle that. Then we're going to define, I don't know. Then we're going to define the earnest money deposit. We could have an initial earnest money deposit due up front at the time of near contract formation. We could have additional earnest money deposit due later in the contract process, parts of negotiations. It's all collectively referred to as the earnest money deposit. It's going to be held in an escrow account by an escrow agent that we will define. The earnest money deposit will be credited to the buyer at closing. So you pay this earnest money deposit, that money will be credited back to you at closing. More on the earnest money deposit when we get to our remedies section of this contract. Then we're going to define who is the escrow agent, who is the one holding the earnest money. It's either going to be, some real estate firms have an escrow account. Most of us don't anymore. There's a lot of risk, a lot of liability. Y'all remember we looked at that thing from the commission that showed us like half of the discipline or half of the complaints were material facts? Once upon a time ago, it used to be half of the disciplinary action was the trust account. And the firm said, yeah, no, we don't want to take that liability anymore. The closing attorney has to have an escrow account, so just let them deal with it. More on that. In this blank, though, we're not going to put, no matter who's holding it, we're not going to put the name of the individual broker or attorney. We need to put the name of the firm. So we're going to have Julie's Real Estate Shop, or, you know, Can We Cheatham and Howe Law Offices, right? We got to have the name of the firm. If the earnest money is in dispute, we're learning that if the buyer or seller terminates, we got to know where we are in the contract and in the contract to know who gets the earnest money. Buyer terminates within due diligence, they'll get their earnest money back. Buyer terminates after due diligence, the seller's getting the earnest money. That's spelled out in here, we'll see it. However, the parties have to agree to release the earnest money. If we terminate, the earnest money just doesn't automatically release. Remember, this escrow agent is an impartial third party, and they cannot release it without permission of both parties. And if either party is unwilling to release it, the earnest money is in dispute, and it can't be released until it's resolved. At some point, the escrow agent is instructed to turn it over to the clerk of court's office and let the two go downtown and hash it out. What we need to understand is that the escrow agent can't release it. If the parties don't agree, then it's in dispute. The effective date of the contract, also known as our contract communication wall. The effective date is the date that the last one has signed and such signing has been communicated. What are the two things we need to go from an offer to a contract? I need the last offeree to sign it, and I need communication of acceptance to cross the line. So the contract helps us by defining that effective date. Then we have due diligence fee, and due diligence period. Due diligence is the buyer's opportunity to investigate the property, to decide, in the buyer's sole discretion, to proceed or terminate this transaction. The whole point of due diligence is for the buyer to learn as much about the property as they possibly can and decide, now knowing what I know, I've learned about all the problems. I've had the inspections, the survey, the pest inspection. I've learned everything I could learn. I've asked the seller to do repairs. Maybe they said yes, maybe they said no, doesn't matter. At some point, the buyer's got to ask themselves, do I want to proceed with or terminate this transaction? The due diligence fee is a negotiated amount paid by the buyer to the seller for the buyer's right to terminate for any reason or no reason during the due diligence period. So this buyer could have a home inspection and get some quotes and find within the first year, they got to address $50,000 worth of issues, that roof, that plumbing, or something, the crawl space, $50,000 the first year of homeownership. Not everybody can do that, right? That's something to take into consideration. That's something to decide. And if you decide that you can't handle that, you have this right to terminate. You have this right during your due diligence period, and you paid for that right. So maybe they have a reason to terminate. Maybe they literally wake up the next day and go, nah, I don't want to buy this house. They have the right to terminate for any reason or no reason at all during the due diligence period. Becomes the seller's upon the effective date, credited to the buyer at closing. It's non-refundable except if the seller breaches. So we said typically the due diligence fee is not refundable. If the seller breaches, that's part of the money that the buyer can go after them for. That would be when it's refundable. Let me go back to this real quick. The buyer's right to terminate, this last sentence here. There's a common misconception out there I'd like to address. The common misconception is that the due diligence fee, the buyer's paying the seller to take their home off the market and not have any more showings. It's a misconception. The seller can still allow showings. The seller can have something called a backup contract that we will talk about. Just because we're under contract doesn't mean showings have to stop. It's up to the seller if we still allow showings. Hear me now. It's not a done deal until that deed changes hands. There's a lot that can happen between now and then. So sellers may still want to explore other options because it's not a done deal. What the buyer is paying for is their right to terminate for any reason or no reason at all. And then we have the due diligence period. We have to agree how long that buyer has. The due diligence period begins on the effective date and goes through 5 p.m. on this date, time being of the essence. Who can remind me what time being and of the essence is? Nothing's implied. Yep. Time being of the essence is our drop dead date and time. This is pretty, this is pretty dang specific, right? 5 p.m. on May 15th, which means the buyer can terminate for any reason or no reason up until 5 p.m. on May 15th. If they terminate for any reason at 5:01 on May 15th, now they're in breach. The due diligence period is a drop dead date time, and it is totally negotiable. Do you want a week? Do you want 4? Do you want 6 months? We got to negotiate it between the party. Buyer's agents, you want to make sure that you get your buyers enough time to have their inspections done, to have a better answer of the loan approval process, right? We want the appraiser back. You want to make sure you give yourself enough time to let the buyer learn about the property. It may depend on the market. When I'm busy, the home inspectors are busy, the appraisers are busy, the pest inspectors are busy, the surveyors are busy, right? So when we're busy, we may need to give everybody more time to coordinate, to get people out to help the buyers do their inspections and investigations. Totally negotiable. You know, if you want more time, maybe the buyer offers more money, right? This is what we mean by negotiable. If you want 6 weeks and you're offering $200, you might get a rejection. If you want 6 weeks and you offer adequate money, then we have this to go. Does that make sense? The more time you want, but buyer's agents, we need to make sure we have enough time to get our buyer so they can learn about the property so they can make this decision. So with the due diligence, let me see. I got a couple questions. So the buyer has to pay for the right to cancel. Yes. If something is discovered during due diligence that the seller is not required to disclose, that's correct, because that's exactly what the buyer's paying for. They're paying for the right to terminate. The seller doesn't have to tell us nothing, right? So if we didn't have that right to terminate, then you're buying a house blind, sight unseen almost. Does that make you a little nervous? We got to give the buyer an opportunity, but guys, the sellers are tied up too. Because remember, they got to find somewhere else to live. So it's not like you're going to say, well, I'm going to terminate. I'm going to take my money back. Sorry. We got it. The contract's got to look out for both parties. And that's what we're doing. If you want to terminate, you have this right, but you got to pay for it. And that's what we're doing with the due diligence fee. I guess that's one way to see it. That's subjective. Kim, there's no right answer to that. Depends on the market. It depends on the house. It depends on the buyer. It depends on the seller. There's no answer to that. Okay. And every once in a while I get somebody that says, my buyers aren't paying due diligence. We're not going to offer that. You know what the listing agent and the sellers are looking for? So you're not going to go far with your buyers. We've got to understand what this contract means for both parties. Is it fair? I don't know. That's not really for us to decide. What we do need to know is, do we have this written down? What does the contract say? When I started in real estate, when I got my license in 2008, maybe when I bought my condo in 06, due diligence wasn't a thing in North Carolina. Due diligence is relatively new. Could this change somewhere down the road? Sure. But today, what does the contract say? Ta-da. If you don't want to use the due diligence, then have an attorney draft up a form for you to use. This is what the contract says. So with the buyer paying due diligence fee, what type of privilege does the buyer have to find out that the property couldn't find out before going on contract? It's almost like I don't want the buyer to pay for a home inspection if the seller's not willing to sell to them. I know the seller's willing to sell, but I got to get the two under control. That's the privilege that my buyer has. We have a legally binding contract. And now that we know that we have the seller in place, now we can pay for the home inspection, the pest inspection, the survey, the appraiser. Again, let's put ourselves in, we're all consumers, right? You may not be out there buying a house, but you're out there buying something. And there's risk when you buy anything. Can we agree with that? Especially when you're buying a house. So what's the privilege for that right to terminate? You could do your inspection and then make the offer and the seller reject it. You've just wasted money on that inspection. Does that make sense? So the contract puts us under, it legally binds the two parties, and now it gives the buyer this opportunity to learn about the property. Still under terms and definitions, we're going to talk about settlement, settlement date, and closing. And I just want to put this, because it's on 2 pages, I just want to see real quick. There is a difference in settlement we're getting ready to define. There is a difference in closing. Every single person in the industry uses these words wrong. You will too, I promise. But to get you through the tests, you need to understand these words. Y'all want me to make a confession? Confession time. I have never attended closing. Anybody ever bought a house, sold a house? You have never attended closing. What we attend with our buyers and sellers is settlement. Settlement is when we go into the attorney's office. Brokers go with your buyers or sellers. We will talk about that. Both parties turn or go into settlement, go into the attorney's office to sign their documents. The buyer's got, if they're getting a loan, they got a stack of documents that looks like a ream of paper. If you bought a house, you know what I speak of. The seller doesn't have as many documents, but they still have some that they have to sign. Maybe they're not going on settlement date. Maybe they are signing them in front of a notary ahead of time. Settlement is also the opportunity for the attorney to gather what the buyer owes. The buyer's going to have to bring some money to complete the transaction. The seller, if they are underwater, they're going to owe money as well. So settlement is when the attorney is getting signatures and monies from the parties. We have to agree on a settlement date. What date do we plan on getting into the attorney's office? Due diligence and settlement are very rarely the same date. Usually we want a period of time between the two to wrap up loose ends, finalize everything. How much period of time do we want before due diligence and settlement? It depends. It's all negotiable. And I do think this is the hard thing for you guys right now, because you want definite answers. You would feel much more comfortable if I told you due diligence was 2 weeks and settlement was in 4. I hear you, but that's not the way it works, you guys. It's all negotiable. And like I said, it could depend on the market. It could depend on, if this is a cash buyer, I don't need as much time as if they're getting a loan. There's so many factors. And I hope you guys hear me. You see these blanks. We have to put these blanks in. The blanks are the negotiable terms. So due diligence will be a date, and generally speaking, unless agreed otherwise, settlement will be, maybe a week, maybe 2. It'll be a period of time after due diligence so we can wrap up loose ends. Delays in settlement just happen. Think of a reason right now why settlement might get delayed. Anything. Yeah, that could cause a delay in settlement. And delays in settlements are so common. Maybe we don't have loan approval yet. Maybe the agreed upon repair isn't fixed yet. Maybe it rained really bad last night and it stormed and nobody has power that we can, get online and record these documents. Maybe it's new construction. There's so many reasons why delaying is so common that we have a built-in delay in our offer to purchase and contract that we'll see in paragraph 12. I always tell my parties to have a plan B. I'm shooting really hard to get you at settlement on this date. Everything I'm doing is to get us in settlement in this date. But not everything is in my control. There are some things I just can't control. I want you to have a plan B. I don't want anybody sleeping in the U-Haul truck tonight. So everybody have a plan B. So we go to the attorney's office, buyers and sellers sign, they bring any monies. Once we leave settlement, the attorney proceeds with closing. Closing is defined as the legal process that results in the transfer of title. Closing is defined as settlement, which we talked about above, completion of a satisfactory title update, Unit 5, closing attorney's receipt, authorization to disperse all funds. So all those lien holders standing there, the attorney has to have permission to pay them. And then the last and final act is to record the new deed to the Register of Deeds. Then and only then is it a done deal. Lots of things could happen between the day we go under contract to the day that deed gets recorded. And it's not finalized. We can't do the big celebration until that deed is recorded. Then and only then is it a done deal. Most of the time, settlement and closing can happen on the same day. And we all, attorney included, work really hard for it all to happen on the same day. I want you to sign and bring your monies on the same day that that deed is changing hands. Always keep in mind, you guys, though, things happen. What if the attorney is about to e-record the new deed and Spectrum has a nationwide outage? What can we do? And it's 4:30 and you don't have time to drive to the courthouse, to the Register of Deeds. If you can't record the deed, we're not closed. So again, just have everybody have a plan B. Once we leave settlement, agents, we go about, do our own thing. Later that day, hopefully, fingers crossed, you'll get an email from the attorney. It's my favorite email in this industry. It's short and sweet. The whole email says, "We are on record." You know what that tells me? Yay, we did it. We closed. That deed changes hands. What questions do I have on the difference between settlement and closing? Again, you guys get in the real world. You'll look at your buyers and sellers and say, we're going to closing on this date. I do it, you'll do it. You guys probably thought you went to closing. For your exams, I need you to see there's a difference. I need you to see there's a difference in settlement and closing. Once you get out in the real world, you'll be like the rest of us. But we've got to be in pre-licensing world. Settlement is when the attorney gathers signatures and monies from the parties. Closing, the last act, is when the deed changes hands. Questions? This warning is just reminding us that there's certain things that the brokers can't do, certain legal things that the brokers can't do. Bottom line, buyers should hire an attorney to perform the closing. So we're going to learn when we get to Unit 21 that North Carolina is rare. We are only one of few that are an attorney closed state that use an attorney. The majority of states use a settlement agent. Again, I'll talk more about that. Why this is important for us, because it's not uncommon for us to have a buyer moving here from another state. And if they know how to do it in the state they are coming from, they very well may look at you and say, do I have to hire an attorney? And your answer is, if the property is located in North Carolina, yes, because we are an attorney closed state. Again, more on that 21. The last thing we're defining here are special assessments. We've said special assessments is just a charge to improve the property. Maybe it's a government special assessment. Maybe it's a special assessment from the HOA. Right now, we're just defining a special assessment. We're going to later address the responsibilities of these special assessments for both buyer and seller. So again, you guys, the first 2.5 pages, we just spent defining things. What does this mean? What does that mean? I think you guys should look at this because it's going to help us, better wrap our brains, better understand. So let's go back now and pick this up. So the purchase price. What is the buyer willing to pay for this property upon the following terms? So the sales price will go in this top line. And then we got to address these fees and deposits. X amount for the due diligence fee made payable and delivered to the seller on the effective date. When is the due diligence fee due? On the effective date. Y'all know how many times I have students coming into post licensing and arguing with me. My pre-licensing instructor said 3 days. What does the contract say? My BIC told me I had 48 hours. What does the contract say? I'm actually asking you, what does the contract say? Let me see your mouths move. By the effective date. Now let's be reasonable, you guys. What if we go under contract at 9 o'clock tonight? We're negotiating after dinner. We get this agreed on and signed. We are officially under contract at 9 o'clock tonight. I'm not driving out after 9 o'clock to get a check and deliver it to you. Let's be very honest. This is where the agents need to communicate. Can we work something out? Can we say, as soon as I get up in the morning, I'll get you that check and I'll deliver it to you? That's not the effective date, but can't we work it out? Does that make sense? And I think that's where we get into all these confusions, because we can. But remember what we're asking ourselves. What does the contract say? If this is what the contract says, what do you think your test is going to say? When is the due diligence date due? By the effective date. Don't fill words in there. Let's see. Is it going to be cash, personal check, bank check, wire transfer, or electronic transfer? Then we have our initial earnest money deposit made payable and delivered to the escrow agent within 5 days of the effective date. We get a little bit more wiggle room with the earnest money to deliver that money to the escrow agent. We may also negotiate additional earnest money. It's still earnest money. It's just usually due at a different time of initial earnest money. Maybe we want the buyers to put more up closer to closing to show that they're serious now that they've made it this far. Maybe the two can't come to terms. The buyer says, well, I can do half of it now and half of it in 2 weeks when I get paid. So we may have different periods of times that the earnest money is due. It's all negotiable. There's no wrong answer there. Additional earnest money is a time being of the essence, because generally speaking, additional earnest money is due closer to closing, closer to settlement. And we don't want to delay settlement waiting on this check to clear the bank. So as we get closer and closer to settlement, we want to make sure we know when it comes in. I'll come back to that in just a second. I'm trying to get it all on one screen, but I don't want to make it any smaller because I want you guys to see it. We'll do it. I'll get it. The rest of this, these blanks here, these are for special situations. So you might have a loan assumption in which the buyer is going to assume the seller's loan. We'll talk a little bit about that in our financing units. You might have seller financing in which the seller is acting as the lending institution. It may also be new construction where we have a building deposit. I don't think you're ever going to have a situation where all these blanks are filled in. So remember, if you're not putting something in here, then make sure you put a 0 so we're all on the same page. One thing I like a whole lot about our offer to purchase and contract, when a need comes up to use an addendum, our contract lets us know. They kind of take the guesswork out of it, right? So again, if we're familiar with the forms, if I'm doing a loan assumption, it tells me I got to go out there and find the loan assumption addendum. If I'm doing a new construction, it tells me I got to go out there and find the new construction addendum. Being familiar with the forms can help us know when applicable addenda come into place. So typically what we have, due diligence and earnest money in a typical transaction. Again, you may have an assumption, seller financing, building deposit. Those are more conditional situations. So we go, let's see, and I'm just going to make numbers up. See, the buyer offers the seller purchase price of $100,000. I'm going to throw up 200 in due diligence. I am just making numbers up. We'll throw in 500 in earnest money. And let's drop a number 300 in additional earnest money that's going to be due on May 15th, just to show this seller that this buyer really is serious. Remember, the earnest money deposit is just showing the seller, the buyer's good faith. So we had a purchase price of $100,000. minus 1,000. I never go off calculator. So now we have the top line minus all the lines in between. So now we have a balance due. The balance of the purchase price is due at settlement. I need another zero there. So we have a purchase price. I left one out there too. Where are my zeros going? So we have a purchase price of 100,000. Buyer put down 200 in due diligence, 800 in earnest money. Assuming we make it to closing, the buyer now just owes $99,000. They've prepaid 1,000 through the form of earnest money and due diligence. Questions? Good so far? I know this is your first time seeing it. First of many, right? Shake your head, yes. All right, let's go and take 10. We come back, we're gonna keep going. Our offer to purchase and contract. I'm going to take attendance. Next provision of our offer to purchase and contract is fixtures and exclusions. So we're going to see this fixture list. Thank you. See this fixture list that we've seen. We saw this on the listing agreement, and the exact same fixture list shows up in the offer to purchase and contract. Remember when we listed the property, we looked at the seller and said, I need you to look at this list, and if there's anything you're going to take, then we need to address it. Now that we're here under contract, the parties may need to agree to exclude any of these fixtures. If you're using standard form 2T, these things are considered fixtures. And in addition to these things, anything that's nailed, screwed, or glued, bolted, welted, right? Something that's permanently attached. If you're using a different contract, the fixture list might look differently. So each fixture list may vary from contract to contract, but 2T, these things are considered fixtures. Remember, a fixture is meant to stay. If the seller is going to take the fixture with them, then we need to make sure we exclude it in the contract. So any fixtures that are going to go are not going to convey. They need to be excluded. And we got to spell those out. Remember our parole evidence rule. The final written word will prevail. So if it's not in here, the seller can't take it. Another thing that may come up with fixtures, we talked about the Uniform Commercial Code in Unit 2, maybe? And that's addressing items that are not leased or not owned. The seller can't convey what's not theirs. So if they're still making payments on it, it's not theirs. If they're going to return it or if they're going to pay it off or whatever, then we need to make sure we hash that out. But if they're not going to convey, then we need to spell out those leased items that are not yet owned. When we remove these fixtures, seller has an obligation to repair any damage caused by the removal of the fixtures in a good and workmanlike manner. Buyer has the right to verify that has been removed in that good and workmanlike manner. So if the seller's taken a fixture, they can't just leave a hole in the ceiling when they rip down the chandelier. They need to patch up the ceiling or maybe put in another light fixture, chandelier, something like that. Contract addresses that. The opposite of fixtures is personal property. So fixtures are meant to stay, personal property is meant to go, unless we agree otherwise. If any personal property is going to stay, then we need to spell it out here. Again, the final written word of the contract will prevail. When you guys are filling out the personal property, I need you to be clear about the personal property. Do not just put in refrigerator. Specifically, which refrigerator does the buyer want? Some people have the refrigerator in the kitchen, the big nice one, stainless steel with the built-in ice maker and da-da-da-da-da. And then they have the beer fridge in the garage. If you say refrigerator, which one you asking for? Which one's the seller more likely to leave? You with me? And there probably won't be beer in it. They're going to take their beer before they leave that beer fridge from the garage. There have been cases, you guys. There have been stories in the past of agents just putting refrigerator in here. Buyer shows up to their brand new home, walk into the kitchen. And in the kitchen where the big refrigerator should be, there's like a 2-shelf college dorm room fridge. If you don't specify what kind of refrigerator you want, did the seller do what they were contractually obligated to do? They left a refrigerator. So I need us to be specific. 2-door stainless steel Whirlpool. If you can get the make and model number, snap a picture, right? We need to be very, very clear what personal property. Don't leave room for interpretation. A fixture is meant to stay. Personal property is meant to go. If they're going to do the opposite of their intent, they must be in the contract. So if a fixture is going to go or personal property is going to stay, they must be in the contract. Provisions 4, 5, and 6 are all about the buyer. So buyer's agents, remember, we're reviewing these contract provisions with our buyers. Specifically, we're having conversations about 4, 5, and 6. 4 is the buyer's due diligence process. Starts with a big red warning. The buyer is strongly encouraged to conduct due diligence during the due diligence period. If the buyer is not satisfied with the results, the buyer should terminate prior to the expiration date of the due diligence period, unless the buyer can get a written extension. But guess what? The seller is not obligated to grant an extension. We agreed at the time of contract formation, this is our due diligence date. Anything is always negotiable. Even if we're already under contract, we can still go back and renegotiate. If we were going to change the due diligence date, that would be an amendment. We have changed something that we previously agreed to. Is the seller, as it says here, is the seller, do they have to grant an extension? No. It never hurts to ask. So if you see that you need more time as a buyer's agent, if you and your buyer need more time, we can always ask, what might make the seller agree to more time? Yeah, show them some more money, right? It's all, we'll call it renegotiable, right? If you're asking for more time, what's in it for me? And the answer might be more money. Maybe that comes in the form of additional due diligence fee. Maybe that comes in the form of additional earnest money. All these points are negotiable after contract formation. Okay, so buyer may continue to investigate the property following the expiration of the due diligence period. The end of due diligence, they're not giving up their right to inspect. They're giving up their right to terminate. The buyer should be inspecting and investigating the property the whole way up to closing. We're going to talk about something called the final walkthrough in just a minute. The buyer should be learning about the property through the whole process. They're not giving up their right to inspect. They're giving up their right to terminate. Buyer's failure to deliver prior to the expiration date will constitute a waiver of the buyer of any right to terminate. If buyer does terminate following due diligence period, anything else is talking about our remedy paragraphs. So I got a whole section about remedies, and a lot of this directs it to that. So we'll see that in just a second. Then we got a list of things for the buyer that they should be encouraged to consider doing during due diligence. So we're not just going to look at the buyer and say, this is your due diligence period, learn about the property. We're going to break it down specifically what they should be doing. I'm only going to mention this here because we're going to spend more time in the contract to closing process when we get to Unit 21. So we're going to talk more about that due diligence period, what the buyer should be investigating. But if we're looking at the contract, we want to try to get loan approval during that due diligence. This note here is reminding us that there is no loan contingency. Remember, contingency might say, I can't buy your house if I don't get loan approval, which means if I don't get loan approval, I'm no longer obligated to buy your house. That's what a contingency says. So I have no contingencies built in. And then we have the property investigation. Buyers shall be entitled to conduct all desired tests, surveys, appraisals, investigations, examinations, including but not limited to. And I think it's important that we recognize that this list is not inclusive. This is just to help get the buyer thinking about what they should be investigating during this due diligence. So we may want to consider having a home inspection, a pest inspection, radon levels, for example. Reviewing of any documents in an HOA. So there's our covenants, bylaws, etc. Homeowners insurance. We need the buyer to get homeowners insurance secured while we're in due diligence. Make sure they're insurable. Make sure they can afford it. If home insurance is too much, and it tips the buyer over their approved amount, we're not going to get loan approval. So we need to make sure we have these things in place. If the buyer's going through a lender, home insurance is required, period, end of story. So we want to get that home insurance secured. I got a whole unit dedicated to insurance. So we'll see that in unit 13. The appraisal of the property. Again, if a lender's involved, an appraisal is required, period, end of story. We'll talk about why and what the lender does with that when we get to our financing units. But we want to have that during due diligence. There's our survey, our zoning, flood hazards, utilities, streets and roads, addressing whether or not they're public or private, and how they're maintained, for example. And then any of those special assessments. I say this list isn't inclusive. There may be something your buyer wants to investigate that's not on this list. Remember, if it's important to my buyer, then it's important to me. So if they say, I want to inspect this, our answer is, okie doke, let's do it. Never look at a buyer and say, oh, you don't have to worry about that. If it's important to them, then it's important to me. Who's buying this house? They are, not me. What happens if the loan falls through after due diligence? The buyer cannot complete the transaction. They are in breach, and they will lose their due diligence and earnest money. If we have to terminate for any reason after due diligence, the buyer's in breach. Can all these be done without a due diligence fee? Yeah. Yeah, if we agree to zero, and we have a 3-week due diligence period, yeah, we have a legally binding contract. It's all negotiable. I need to talk to that listing agent though, because they're not best representing their seller, right? We got to look at both sides of it. We got to look at both sides. So sure, if we agree to zero, we have formed a contract with zero. Also, during the due diligence, the buyer may have to sell or lease an existing property. I'm not creating a contingency here. We're just letting the buyer know. If you have to sell or lease an existing property, you may want to consider having it closed or leased while we are still in due diligence, or be reasonably satisfied that closing will take place prior to settlement. If we go past due diligence and the sale of that property falls through, buyer's in breach, and we have to terminate. Repairs and negotiations. Here it is. Unless the parties agree otherwise, this property is being sold in its current condition, and that's just a fancy way of saying as is. What's the seller have to fix? What they have to repair? Absolutely nothing. They don't have to change a light bulb if they don't want to. If they agree to do anything, then we can amend this sentence. I have a form for that. Seller may or may not engage in negotiations for repairs. As a buyer's agent, we can always ask the seller to do repairs. Understand they're under no obligation to do so. The seller may agree to do all the repairs that the buyer wants. They may agree to do none of the repairs, or they may agree to do some of the repairs. It's completely negotiable. But bottom line, if we're asking for repairs, and whatever the seller says, however they respond to that, the buyer has a decision to make, because now they know what they know. Now they know the problems of the home. Now they know that the seller is or is not willing to change that light bulb. Now they have all that information. And now, knowing what I know, do I want to proceed with or terminate this transaction? Buyer's obligation to repair damage. So if the buyer or any of their agents and contractors damage the property, so maybe the home inspector damages the property, then the buyer, buyer's expense, they'll promptly repair any damages resulting from the activities of their agents or contractors. This repair obligation will survive any termination of this contract. So if the home inspector damages the property, the buyer terminates, they're still on the hook for fixing the property. That's what we're saying. The repair obligation will survive. If you indemnify somebody, you hold them harmless. Other than the terms of this contract, the buyer will indemnify the seller. So really, we spell out what each party can go after each other for. We're not going to be able to have options to go after them for other things. So indemnify, you're holding them harmless outside of the right of this contract. Talk to your attorney. Buyer's right to terminate. Provided the buyer has delivered an agreed upon due diligence fee, buyer shall have the right to terminate this contract for any reason or no reason. All they have to do is deliver written notice to the seller of the termination. I got a form for that, by the way. During the due diligence period, time being of the essence, if the buyer delivers the termination, this contract shall be terminated and the earnest money deposit will be refunded to the buyer. The buyer doesn't even have to tell the seller why they're terminating. They just have to provide written notice that they are. And upon receipt of that written notice, if we are still in due diligence, time being of the essence, then the earnest money deposit will be refunded to the buyer. And we got this last little piece here, pretty important. That's why it's caps and bold. What's it mean when you see caps? Somebody's typing in caps. It's like they're shouting at you, right? And what do they do when they bold those caps? They're standing on the mountaintop screaming, okay? So closing shall constitute acceptance of the property in its then existing condition unless provision is otherwise made in writing. Once that deed changes hands, congratulations, Mr. and Mrs. Buyer. This home and all its problems are now yours. Here's the key. Closing constitute acceptance of the property. It's pretty simple. I hinted around the final walkthrough earlier. We're going to see it here in just a second. Final walkthrough, the buyer seeing the property as close to settlement as they can. I try to get mine in like on the way to the attorney's office, because when they sit down at the attorney's office and sign at settlement, I need them to know what it is that they're signing. So what if we do the final walkthrough and we see a bunch of trash and garbage in the home? Or what if there's still a lot of personal property in? Or what if this is the first time that we're ever seeing this property vacant? And now we see there's a reason that there was a picture right here on the wall. And that picture was to hide the hole. Your buyer's going to look at you and say, I want that hole fixed. We have two choices, and I want all the trash out. We have two choices at this point. We either go to closing and accept the property in its then existing condition, or we don't. Don't encourage your buyer to sign and then we'll work it out. We got to have everything worked out before we sign. If your buyer is not satisfied with the acceptance of the property in its then existing condition, we're on our way to the attorney's office anyway. So if we do agree to something otherwise made in writing, now we're all sitting in front of an attorney. We can get them to draft something up for us. Don't tell your buyer to sign and then we'll get it fixed later. Is everybody hearing me? Closing shall constitute acceptance of the property in its then existing condition. And if your buyer sees a bunch of problems with the home, a bunch of things that we've never seen before because we've never seen it vacant, and there's a whole bunch of trash and debris, and they say, I don't want to deal with this, they have a decision to make. And that's a pretty tough decision, right? Especially if they don't have a plan B and they thought they were sleeping there that night. Always tell your people to have a plan B. Questions? anything on provision 4, which is the buyer's due diligence period. If we can consider this, the idea of settlement is to settle everything between the buyer and the seller. We want to finalize everything. And when that deed changes hands, when we go to closing, they should be done with each other, unless provisions otherwise made in writing. Then we got buyer representations. These are things that the buyer's representing to the seller that the seller should be able to rely on when deciding whether or not to enter into a contract with this buyer. One of the biggest questions the seller has is, can they afford? Can they afford to buy my home? They're telling me they can, but we need to make sure that we have the representation that they have the funds. So we need to represent if they're going to be a cash buyer or if they're going to get a loan. Again, 14 and 15 are our financing units, and thereafter 10. So we're getting ready to talk about that loan, what all FHA, VA, all that good stuff means. But right now, we're just representing how we intend to get the funds to purchase the property. If you're getting a loan, you want to support that with a pre-approval. We'll talk about that. The buyer needs to represent that they do or do not have to sell or lease other real property in order to qualify for a new loan. If they do, then we need some more information. We want to know what the other property address is. Is the property they have to sell or lease under contract? If it's not under contract, what's its story? Is it going to be listed soon, or it is listed, or this seller's going FSBO? We're reminded in the note that it's not conditioned upon the sale or lease of the buyers of the property. If the parties agree to make this contract condition by the sale or lease, then we need to have a contingency addendum drafted by an attorney. That's one thing we don't have a pre-printed form for, is a contingency. So if we're going to create a contingency, I got to sell my house before I can buy yours. The contract tells us that we need an attorney to draft that for us. The buyer has to represent whether or not they've received the RPODs and the MOG. So the buyer's representing to the seller that they have received the RPODs and the MOG, or they have not received the RPODs and the MOG. And if so, the buyer shall have the right to terminate without penalty, which means this is another example of when they could get their due diligence fee back. And this goes down within the end of the 3rd calendar day. This is also spelled out for us in our RPODs and the MOG. So if they've not received it, they have that right to terminate. Again, this is a case where they would get both earnest money and due diligence back. They're not terminating because they don't like how it's completed. They're terminating because they didn't receive it. Remember, these are our mandatory forms with optional disclosure. So all they're acknowledging is receipt. We go through that same little exercise in the MOG. Buyer has received it, they have not, in which case they can terminate without penalty. And then we got to spell out each party's obligations under the contract. So 7 or 6 spells out the buyer's obligations. Special assessments we defined earlier, but now that we're talking specifically about the buyer's obligations, the buyer's going to be responsible for any special assessments that are approved after. settlement. So if they're on the table for discussion right now, they might not be agreed to yet. They might not be approved until after settlement. I think a good rule of thumb when it comes to special assessments, whenever they're approved, the current owner is responsible for them. So anything approved after settlement is going to be the responsibility of the buyer. The buyer is responsible for certain costs, anything to obtain their loan, charges by an owner association, anything to do with the contract, appraisal, title search, etc. Just kind of spelling out some specifics, kind of all scattered throughout the contract as well. And then authorization to disclose. The lender needs a copy of the contract. The closing attorney needs a copy of the contract. The appraiser gets a copy of the contract. How do all these people get copies of somebody else's contracts? Because we give them authorization to disclose. So the people that need the information to do their job, to get us to closing, we have that permission to do so. We'll see that again with sellers. Questions on the buyers, 4, 5, and 6, buyer provisions. Seven and 8 are all about the sellers. Listing agents, these are the conversations we need to have with the sellers specific, particularly it's 7 and 8. So our seller representation, again, these are things, representations that the seller is making to the buyer. The buyer should be able to rely on this for accuracy when deciding if they want to enter into a contract with this seller. First thing the seller wants to represent is how long they've owned the property. Some lenders care about the length of ownership. Remember me telling you about my builder and our novation, and they only owned it for 89 days, and FHA requires 90. So some lenders care about the length of ownership. Seller's going to represent that. If the property was built prior to what year? I moved it so you couldn't look. 19, what's the lead-based paint year? 19. I see hamster wheels just a running. Yeah. Anything built prior to 1978, we're going to require the lead-based paint hazard addendum. By the way, you guys, once you get out of your exams, once you get out of post-licensing, you don't need to know this data anymore because it's right there for you. So there's the good news. It's one of those things that you can just kind of knock it out of your head at some point. But by that point, it's so ingrained in you. You know that year better than you do your own birth year, right? So 1978, maybe you're lucky and you were born in 78. If it is, and we're going to have the lead-based paint hazard addendum. Owners Association and dues. The seller is, remember, this is the seller representations. So the seller's representing to the buyer if we are in an owners association. Do we have dues? Do we have documents? This is a list of documents that may be included with that owners association. We saw this exact same list in the listing agreement. So we had this conversation with the sellers. What are the documents you have for the owners associations? Let's go ahead and gather it because we know it's going to come up again in contract. We know the buyer's going to want to review it. We're going to specify the name of any association, what the dues are currently. X amount per, some HOAs go per month, some go per year, some may go per quarter, right? So how and when are the HOA dues? And I got a place on here for 2 HOA dues because some owners associations, you may have like the mandatory owners association and then an optional for the pool, for example. So all we're doing is representing to the buyer the information. So if there's more than one owners association, then we want to address that, top of page 9. To the best of the seller's knowledge, there is or is not a fuel tank on the property. We talked about specifically underground storage tanks in unit 20. I got a place here to identify 2 tanks. This is in the listing agreement as well. So you currently is in use or not in use. It's owned or leased. It's above ground, below ground. What's the fuel? And who's the contact information or fuel vendor? Again, seller just representing this information. Tank 2. And the other thing that the seller needs to represent is the property is or is not subject to any leases. If they are, I got a form for that. The additional provisions addendum, that's one we're going to talk about. We're going to look at some other addenda, and we will talk about that when we get there. In North Carolina, properties are sold subject to any leases. Buyers buy acquiring the current lease and the current tenant. Buyer has a right to know what they buy, right? So if you're going to buy a property that has a lease and a tenant in place, that information, the rent, the lease, all that is going to be in that additional provisions addendum. The seller needs to provide that to the buyer so they know what they're buying. Questions on the seller representations? Then we have the seller's obligations. What's their number one obligation? To provide that clear marketable title. They got to show evidence of title. They're going to provide any payoff statement so the attorney can make sure that they're paying off all lien holders to the penny. Seller obligation if they're a non-foreign status. Not a foreign person defined by, there's the Foreign Investment and Real Property Tax Act. This is for tax purposes, non-foreign status. This also comes up in the listing agreement. So if your seller says that they qualify, they fall under this Foreign Investment and Real Property Tax Act, then we can have this conversation up front. This is like a case by case, but it's in the listing agreement. And the listing agreement we can kind of use as a jumping point for conversation. So we can ask the seller, they're going to know if they fall under this act or not. If not, we can just put it in Google and help them look it up, get the attorneys involved. But it has to do with taxes and how taxes after the sale are addressed. Authorization to disclose, we saw this with the buyers. So again, the lender needs a copy of the contract, the attorney, the appraiser. This just gives us authorization to disclose, to release that information. Access to the property. Sellers shall provide reasonable access to the property through the earlier of closing or possession by the buyer, including but not limited to their representatives or agents. The seller can't deny the buyer to do their investigations. The seller can't not let the home inspector in. The seller can't not let the appraiser in, the pest inspector, the surveyor on the property. They've got to allow the buyer's agents and representatives to access the property, reasonable access to do their due diligence. They also have to allow that access for the final walkthrough. And all of this obligations, existing utilities is at the seller's cost. So we got to keep the power on. We got to keep the water on. I know many times in vacant homes, the seller may want to cut it off to save money, right? The home inspector can't inspect if we don't have power and water. So the seller has a duty, and if it's off, they should turn it back on. Because what does the contract say? Seller's obligation includes providing existing utilities. Removal of seller's property. They're going to remove all personal property and all garbage and debris from the property. We got to get it out. We got to get it out. Other states may say, well, you have 3 days after closing to get your stuff out. North Carolina, we need it out before settlement. When I do that final walkthrough, I need to see it completely vacant, unless we agree to any personal property, of course. There's that indemnification. Seller's going to hold the buyer harmless except for the things spelled out in his contract. Designation of a lien agent. This is talking about our mechanics liens, making sure any of those are paid off, all the satisfaction of liens, all those lien holders. That's the seller's responsibility, obligation to make sure that's taken care of. That's that period of time between settlement and closing generally, before that deed changes hands. This is the seller's biggest obligation right here. Good title, legal access. This is the paragraph we saw back in Unit 5. Seller shall execute and deliver the general warranty deed in recordable form no later than settlement to convey fee simple marketable title without exception for mechanics liens, lis pendens, judgments, encumbrances, etc. This property must have legal access to a public right of way. To the seller's number one obligation is to be able to provide clear marketable title. And if they can't, they are in breach. Government of compliance, this is addressing any zoning issues that might come up. Any like an off-site boat slip, for example, or an off-site storage or garage space. Governmental compliance. Basically what this is saying is that the seller is encouraged to disclose anything that's not governmental compliance. Just because the seller is encouraged to disclose, does that mean that they have to? They still don't have to disclose anything, right? However, if they don't disclose and the buyer finds them during due diligence, they can ask the seller to cure the violation. If the seller doesn't, the buyer has a choice. Buyer said, I found this issue. Will you fix it? Seller says, nope, I'm not going to do it. If seller does not cure the violation, buyer may choose to accept the violation and go to settlement and closing, or they can terminate. And this is another case where they'll get their earnest money and their due diligence fee back. We're really encouraging the seller to disclose what they know. And that's all they have to do. They don't have to fix it or cure it. They're just encouraged to disclose it. Because if the buyer finds it, or when the buyer finds it during the due diligence, now the buyer has an out. So listing agents, to protect your sellers, have them disclose. And that way we can't lose this buyer. This also shows up in our listing agreement, so we can have this conversation. Deed taxes and fees. Seller's going to pay for the deed preparation. I think we saw this the other day when we were talking about seller net. Seller pays for the deed preparation. They pay for excise tax, etc. We're going to talk about sellers and buyers, debits and credits, when we get to Unit 21. If we're going to agree for the seller to pay any of the buyer's closing costs, maybe we negotiate the seller's going to pay X amount towards the buyer's closing costs. We're going to put that in here. This is another big place, you guys. If the seller's not paying anything, we need to make sure everybody's clear on that. If we agree to 0, never leave a blank. Owner's fees, here's our special assessments again. Seller's going to pay anything by an owner's association. Well, that's the owner association, not special assessment. Special assessment, seller shall pay in full all special assessments that are approved prior to settlement. So anything that's already been approved, the seller's on the hook. Again, a good rule of thumb. When it's approved, whomever owns it at that time is responsible for it. Late listing penalty. If the seller failed to pay 2023 taxes, they must clear those up. That's another lien holder they need to address. Negotiated repairs. If the seller agrees to do any repairs, they should be made in a good and workmanlike manner. We're going to agree to do a home warranty. Sometimes buyers and sellers negotiate a home warranty. So we have those specifics. And then the last piece of the seller obligation is what happens if they breach, and all that's covered in paragraph 23. 23 is all about remedies for breach. So we're getting there. Questions on the sellers. 7 and 8 are about the sellers. 4, 5, and 6 are about the buyers. Charges by an owners association. The attorney is the one dealing with the owners association to make sure that transfer happens. We got to get the information from the current owner to the new owner. How those fees are handled, what all's involved, who's responsible for what is spelled out in here, unless agreed otherwise. The homeowners association may have something different than this in which the parties need to agree. Otherwise, who's going to be responsible for what? But there is some more work involved with an owners association to make sure we get everything transferred. Prorations. This is a big thing we're going to talk about in Unit 21. When we talk about debits and credits, we're going to talk about prorations. We touched on these back in Unit 3 when we talked about taxes. A proration is just taking a shared expense and making it fair between the parties. So for example, if you were to buy my house today, it's April 18th, you buy my house today. Is it fair for either one of us to be responsible for the entire 2024 taxes? I didn't own it the whole year. I shouldn't have to pay the whole year. You didn't own it the whole year. Should you have to? So how do we make it fair? We prorate this year's taxes. It's a shared expense. So we'll talk about how we prorate it in 21, how we share it, how we make it fair. Other things that we may prorate, we'll talk about. If we negotiate any personal property of value. I can't tell you how many times I've been showing properties and we walk into the garage to see a really nice car. I don't know cars that well, but you know, something sporty, something nice, something red. And the buyer says, does the car come with the house? And in which case I say, anything's negotiable, right? They can put a price tag on anything. So if you really, really want the car, that would be a personal property. That would be an outside bill of sale. That sale would not happen in this contract. And then we'd have to prorate this year's property taxes. I'm sorry, personal property taxes. Other things we can prorate are rent. If there's a tenant, we can also prorate homeowners dues, owner association dues. So again, if they're monthly, you buy my house today, it's not fair for either one of us to pay April's HOA dues, right? So we're going to make it fair by prorating it. And that's what prorating is all about, this shared expense, making it fair. Condition of property, risk of loss. If I can just sum this up, we're going to break it down a little bit, but to sum this up, it's still the seller's property. They're responsible for the property until that deed changes hands. I need them to keep insurance on the property. So the other piece of this is, what if something happens to the property while we're under contract? We go under contract and the house burns down, or a tree falls on the house. What happens? The answer is, what does the contract say? Condition of property. If the property is not in substantially the same or better condition at closing as on the date of this offer, buyer may terminate this contract with written notice. If they terminate for this reason, they will get their due diligence and earnest money back. I don't care where we are in the contract process. So we go under contract, we get out of due diligence, and the house burns down. Buyer chooses to terminate, we'll get them their earnest money and due diligence back. If the buyer does not elect to terminate, house burns down and buyer doesn't terminate, in addition to the property, the buyer's also going to get the proceeds of the seller's insurance to rebuild. So if the house burns down, it's not over yet. The buyer has a decision to make. And there's a really good chance the buyer's going to look at you and say, what do I do? And the best thing I know, once I read this to them, the next thing I know to do is advise them to talk to their attorney to fully explore all their options before they make that decision. Risk of loss is reminding us that the seller is advised not to cancel any existing insurance on the property until we know that that new deed has recorded. It's still the seller's property. They're responsible for the maintenance, the upkeep, the insurance until that deed changes hands. Questions on that? We mentioned this delay in settlement. Our contract gives us a 7-day delay. So if we're scheduled to close on April 20th, for example, or go to settlement on April 20th, and we find out maybe we don't have loan approval. Maybe we have an agreed upon repair that's not been repaired yet. What if? For whatever reason, we cannot close as scheduled on the 20th. There's a 7-day delay built into the contract. So what does that mean? The 7-day delay. One party's the delaying party. Let's say, for example, we can't close on the 20th because we don't have final loan approval yet. That would make the buyer the delaying party. They're the ones holding us down, slowing us down. The seller then, in that example, is the non-delaying party. And this 7-day delay says that the non-delaying party has no choice but to sit still and be patient and hope we get loan approval. If the non-delaying party terminates within that 7 days, they're in breach and they suffer the consequences of breach. If after 7 days we still haven't closed, day 8, now the non-delaying party can exercise their right to terminate. And the delaying party would suffer the consequences of breach. So the 7-day delay, all we can do is just sit still and be patient and hope that whatever is causing this delay gets worked out. What do you guys think? Could we agree to a new settlement date? Could we negotiate and agree to a new settlement date once we're under contract? Sure, just an amendment. So if we see on the 18th, we're not closing on the 20th, and maybe we're not even going to close now until May, we may want to agree to a new settlement date, in which case we can amend. We got a form for that to amend the contract. And settlement date is one of those that we can amend. By the way, there's an old joke down at the commission, and the answer is we got a form for that because there's a really good chance they don't provide the forms, but there's a really good chance that there is a form available for that. I'm not kidding when I'm telling you, NCAR, we got like hundreds of forms. So there's a really good chance that there's a form for that. And if there's not, what are we going to do? Draft one up for them? Let me type this up for you real quick. No, we're going to get our attorney involved. We're going to call the attorney. Question comes in, what happens in the case of new construction? New construction is almost always delayed. There's a separate new construction contract that we would use instead of this one that would address that specific situation. Because new construction, you're dealing with like weather and labor and supplies. I mean, I'm not going to say always delayed. That's why I say almost always. But with new construction, you can definitely bank on delays. And that contract specifies that. Yeah, I'm not going to say always, because somebody somewhere has a time that they close on time with new construction. Good for you. The rest of us, new construction is almost always delayed. Bank on it, count on it. You know, if it starts raining today and it doesn't stop for the next week and a half, what can I do about that? You know, so when your buyer says, I want to build, expect delays. Let's see. A few more and we'll take a break. Don't go anywhere just yet. We're getting there. Possession. This is one of the biggest places you guys like to argue with me because you guys bought a house and you had something different happen. But what I'm going to say to you is, what does the contract say? So possession, when can the buyer get possession? Including all means of access to the property, such as keys, codes, garage door openers, etc., shall be delivered to the buyer when? Once that deed changes hands. Some of you might have gotten the keys at settlement. Some of you know somebody that got the keys at settlement. It happens all the time. It's not advised. It's risky. Remember, it's still the seller's until that deed changes hands. The responsibility, the risk is on the seller. So the deed hasn't changed hands yet. You give your buyer the key. They run over to their new home, fall down and hurt themselves. Who's that risk on? Seller. It's still their home. What does the contract say? All access to the property should not be given to the buyer until that deed changes hands, until it is theirs. We may do a buyer possession before closing or a seller possession after closing. Either one of these, I got a form for that. And we're going to talk about those. We got some commonly used addenda that we're going to look at, and these will fall under that. So we'll see those, talk more about those. So as mentioned, scattered throughout the contract, when a need to use an addenda comes up, the contract tells us. Now we have the commonly used addenda kind of in one nice, neat little package. So we can check. We can use this as a checklist. For this particular buyer, this particular transaction, these are the addenda that we need, and these are the addenda that should be added to the contract, to the offer, and upon acceptance become a contract. We're going to talk about some of these, not all of these yet. We'll talk about the ones on the syllabus. You'll meet more of these when you get into post-licensing. And then, of course, when you get out in the real world as the situation comes up. So we're going to address some of these commonly used addenda. We won't see that till next week, though. Under North Carolina law, just in case we forget, real estate brokers are not permitted to draft any addenda to this contract. So that's scattered throughout here as well. Questions? It's good stuff, isn't it? There's a lot in here. 17 pages for the seller to sell and the buyer to buy, right? But there's a lot. I mean, think about the price tag on homes. Think about the things involved. There's a lot of risk on both sides. And this contract is designed hopefully to protect everybody. It's a lot. I know this. Remember, you're just meeting it for the first time, first of many. Let's go ahead and take our last break. When we come back, we're going to wrap this up. Talk about what next week's going to look like. Maybe for some reason it's not letting me respond. Reach out to me outside of class and we can discuss, please. Welcome back. So I am taking attendance. Continuing right along. These next couple sections, you guys will notice that the yellow is not as bright. The yellow is not as brilliant. The syllabus says, like, look this stuff over, but don't spend as much time on this as what you do the rest of it. Okay, so there's a reason why it's a different shade of yellow. It's important, yes, but it's not as important as the other things that we've been talking about. A lot of the rest of this is what they call boilerplate stuff, which is common things you'll find in sales contracts. So there's nothing like special or unique about this. It's very, very typical of a contract. So we talked about an assignment. With an assignment, all the terms stay the same. The only thing that changes is the names of one of the parties. And contracts need to spell out whether or not they can be assigned. This contract may not be assigned without the written consent of all parties. So could you assign this contract to somebody else? Sure, as long as you have the written consent of all parties. So it's addressing that. Tax deferred exchange, also known as a, I just lost it. Oh no, we're going to talk about it in a future unit, but a tax deferred exchange is a program for investors. 1031, thank you. A program for investors that allows them to defer paying taxes on the sale of an investment property. As long as you're using the proceeds of the sale to buy another investment property, you can defer paying those taxes. It's a great program for investors. I got a unit dedicated to investors. So we're going to talk about the 1031 exchange, tax deferred exchange, when we get there. Parties, again, we're not spending a lot of time here, but I know sometimes people don't believe me, so I like to show you. This contract shall be binding upon and inure to the benefit of the buyer and the seller and their respective heirs, successors, and assigns. And again, I ask you, when do heirs kick in? Once the parties passed away. Death is only an out when you're negotiating the offer. Once you're under contract, death is not an out. Boilerplate stuff. Again, glance over it. That's why it's not as yellow as the rest of it. Just making sure here there's nothing. Computation of days. When you're talking about contract days, contract speak, a day is a day is a day. Weekends count, holidays count, it's a calendar day. So a day is a day. Also, any reference to a date or time is that date or time in the state of North Carolina. It's where the property is located, not the people. There was an incident several years ago. I remember when that sentence was added. There was an incident several years ago where a buyer in California terminated on the due diligence date at like 4:30 California time. But we had already passed due diligence North Carolina time. And it became a thing. And so now, to make sure we don't have any incidences, we're referring to the date and time in North Carolina. All right, back to bolder highlighted stuff. Remedies. Paragraph 23, make a note. Paragraph 23 on page 13 spells out the remedies. Once upon a time ago, the remedies were kind of scattered all throughout the contract. Everything was here. You just had to go around and find it. A couple years ago, one of the revisions, they put the remedies all in one nice, neat package for us. This was a great improvement. Now we don't have to go searching for it, right? We have all the remedies right here. The only thing I wish is that they wouldn't have stuck it at the very end. I fear that it gets blended in with the end of the contract. So just make a note. 23 on page 13 is the remedies, spelling out what happens. First off, breach by buyer. If the buyer breaches, seller shall be entitled to the earnest money deposit, the payment of the earnest money deposit, and the due diligence fee that we've already collected together serve as the seller's liquidated damages. So if the buyer breaches, the seller gets the earnest money and the due diligence. This is the liquidated damages and are the seller's sole and exclusive remedy. The seller can't go after the breaching buyer in court. They can't try to demand more money. This is it. Listing agents, make sure your seller understands this when an offer comes in. Because if the buyer terminates after due diligence, that earnest money and due diligence fee is all the seller gets. Making sure there's nothing else here. So breach by buyer, again, look through that. Breach by seller. If the seller breaches, buyer's got some choices. They can terminate, and they're entitled to their earnest money and due diligence, along with reasonable costs actually incurred by the buyer in connection with their due diligence. So if the seller breaches, the buyer's got two choices. One of those is to go after the seller for compensatory damages. Compensatory damages are those money damages that you can prove that you paid as part of this transaction. Can you prove that you paid due diligence fee? Can you prove that you paid earnest money deposit? Can you prove that you paid a home inspection and an appraiser and a surveyor? All those fees associated with the buyer's due diligence. The buyer, one option they have is to terminate. If the seller's not willing to sit down and write a check, then the buyer can take the seller to court. The buyer's other option, and they got to choose, this says or. So either we terminate and take the money, or we elect not to terminate, treat this contract remaining in full force, and seek the remedy of specific performance. Specific performance, the buyer could take the seller to court, and if the buyer wins, the judge can force the seller to perform. The judge could force the seller to sell. Attorney's fees, if we do have to have legal proceedings to collect costs or any monies to collect. General statutes kick in. One thing that the general statutes say, and you can just put this in Google if you really want to, but one thing the general statute said in this case is if we have to take each other to court, the contract's pretty clear about what happens if we don't continue. If either party gets out during due diligence, after due diligence, we take this thing to court. The first thing the judge is going to pick up is this contract. And they're going to see what the parties agreed to. They're going to look at the terms of the contract. And whichever party's entitled to collect will, because it's spelled out in contract. What this attorney's fees, this general statute's getting at is the losing party may be also on the hook, not only for their attorney's fees, but yours as well. So not only are you getting the money back that you're going after, but you may not have to pay your attorney's fees because the losing party will call them. So again, just directing us to these general statutes. Obviously, if there's questions, then outside of this paragraph, then we need to encourage our buyers or sellers to talk to their attorney so they can legally advise them on how to proceed. Outside of this contract, I can tell you everything that's in here, but then there's going to be a lot of what if or what should I do? And that's offering legal advice. That's getting out of our way. Questions on these remedies? Spells it out. Breach by buyer, breach by seller. This offer shall become binding contract on the effective date that we previously defined. Addressing again what happens if the money's not due on time. We saw that at the top of page 2. I have a place for 2 buyers and 2 sellers to sign. If we have more than 2 buyers, if we have more than 2 sellers, we have an additional signatures addendum. And we can add as many signatures as we need to. Remember grandma's estate? She left it to the 8 grandkids, and all 8 grandkids were married. So now I got 16 people that are selling this home. I need all 16 to sign this contract or the additional signatures addendum. If one of the 16 doesn't sign, we can't convey. So we need to make sure everybody's on the same page. We need to have signatures. We also have a place if the buyer, seller are entities. So if a corporation or LLC is purchasing, there's going to be somebody that's authorized to sign on behalf of the entity or the LLC. Technically speaking, this is what, page 14? Technically speaking, the signatures indicate the end of the contract. So the contract ends right here where buyers and sellers sign. The last couple pages are supplemental pages to help fulfill the terms of the contract. So everybody signing here. Congratulations, we're under contract. Communication of acceptance. The rest of this then is addressing various things. We blew through the wire fraud advisory. I didn't talk about it in the agency agreements because I knew I wanted to talk about it here. We saw a wire fraud warning to the sellers. We saw a wire fraud warning to the buyers. Now that we're looking at the contract, we're looking at a wire fraud warning to both. And again, this is not in all caps on accident. Wire fraud in real estate has gotten really big, really fast. Monies that are being sent to the attorney or being paid by the attorney, for example, to the seller, that are done electronically. We don't want them to get intercepted by the scammers. So we need to make sure that people are transferring wire transfer instructions in a way that it can't be intercepted by the scammers. The best thing we can do to protect our buyers and sellers from wire fraud is to look them in the eyeball and say, I will never email you wire transfer instructions. If you ever get an email with wire transfer instructions, treat it as a scam. I don't know if it is or not. Treat it as a scam. This is what's happening. The hackers are getting into my email, and they're sending an email from me to my buyers that say, transfer your closing money. Here's the information. My buyers trust me. They think that I have their best interest. So as soon as they get the email, they send their money directly to the hackers. So the best thing we can do is look them in the eyeball and say, I will never email you this information. If you get an email from me, I need to know because I've been hacked. My email, y'all, our emails, our Gmails are about as secure as our closet doors, right? You can do 2-step verification. You can take some couple extra steps. Don't use password 1, 2, 3, 4, right? Like we know all this good stuff, but we still need to take the couple extra steps to protect our buyers and sellers. So how do they get this information? How do they get the wire transfer information? They need to go old school. They need to pick up the phone and call the closing attorney's office to get or receive that information over the phone and tell them that they need to call either the number you give them or the number that they look up. Don't call on a number from the email, because when you call that number in the email, you're calling the hackers directly and saying, where do I send this information? We got to go old school with this. Pick up the phone, give them the attorney's number, but make sure they understand if they're going to wire in their proceeds or their sales costs, they need to make sure that they are very, very cautious, and we need to do what we can to protect them. Buyers may do a wire transfer for their funds. They may also do a cashier's check. Ultimately, it comes down to the attorney's preference. Buyers deal with wire transfers more, but the sellers could have their proceeds wire transferred to them, in which case they need to understand as well. Wire fraud, y'all think about the dollar signs attached to real estate and how easy it is. Wire fraud has gotten really big, really fast. We are all on alert now. It must have been 2019. It was the year before COVID. We went to a wire fraud seminar in Raleigh. Lane and I did. It was really interesting. Back in 2019, when we went to this seminar, they said at that point, billions of dollars, that's with a B, had been intercepted by the closing attorney, through the closing attorney. That was in 2019. Where are we now? I have no idea, but hopefully we've created awareness. We've generated awareness. We have these big red warnings in here. We've got to have this conversation with our buyers and sellers. Remember our old car. I'm trying to protect them. I'm trying to protect their money. And this is one place that we absolutely can do that. So have this conversations if they're going to do a wire transfer. Questions on this? Also, y'all, FYI, watch out. You're going to be dealing with your buyers and sellers. You're going to have some, you know, special information. You may have banking information. You may have social security numbers, right? So just make sure when you're accessing your email, when you're pulling those e-files, make sure you're on a secure network. Don't hook up to a public Wi-Fi. Do you know who can access a public Wi-Fi? The public. So if you want to go work this afternoon at Panera Bread, I think that's awesome. You want to work on your files and you want to pull up that stuff at Panera Bread this afternoon, I think that's awesome. Don't get on Panera Bread's Wi-Fi. Get on your mobile hotspot. Does that make sense? Take those couple extra steps to protect. Yes. On that wire fraud seminar, they showed a video. The FBI was there as well, by the way. And they showed a video of a lady in Panera Bread, and she didn't look any different than any other of us. It's not like she was wearing her I'm a hacker t-shirt. And she sat down in Panera Bread, sat down at a table, and she created a Wi-Fi called Panera Bread 1. And within seconds, people all over the restaurant were hooking up to it. It was amazing. You guys need to be careful. Let me see some head bobs telling me you're hearing what I'm saying. Awesome. Be careful. Protect your client's information. That's why this wire fraud warning is here in caps. Questions on that? Then we have our notice page. Remember we talked about the acceptable forms of communication? Here it is. Here's our notice information. How do we want to communicate? You may want to put your buyers and sellers contact information. Your firm may have a policy. Some firms don't want to share this. Others don't care. However your firm wants to handle this, whatever you may want to show. The important part of this page is the confirmation of agency and notice address. This is the only place in the offer to purchase and contract that you and I belong. And what we're doing here is not only giving you my contact information, but I'm identifying my role. What gives me the right to be in this transaction? Selling firms on the left, buyers on the left, sellers on the right. So the selling firm, we need to identify how they're acting. Are they today? Are they a buyer's agent, a seller sub-agent, or a dual agent? We need the role of the firm, the firm's license number and mailing address. And then we're going to list who the individual selling agent is, whether or not they're acting as a designated dual agent, check if applicable. The selling agent's license number, contact information. How do you want to be notified in regards to this contract? Sellers on the right. So again, we got to identify who the listing firm is, what their role is. The listing firm is either going to be the seller's agent or a dual agent, their license number, and then same little thing over here, the individual listing agent. Are you acting as a designated dual agent if applicable? And what's your contact information? This is the only place that we belong in the offer to purchase and contract. The only reason we're here is to tell you how to communicate with me and what's my position. Why do I get a right to be here? We've got to identify that role. What questions do I have on this? Does that work? Can you hear me now? You still can't hear me? You can? Good, 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 good. Last page is acknowledgement and receipt of money. So as that due diligence fee changes hands, as the earnest money deposit changes hands, the person receiving it needs to acknowledge that they've received it. They need to sign. So first we do the due diligence. Typically, when we go under contract, the buyer will meet up with, the buyer's agent will meet up with their buyers. We go under contract, I'm going to say, I need you to go get me 2 checks. When and where can I meet you? Many people don't have a checkbook anymore. So maybe I'm meeting you in the bank while you run in and get me some money orders or cashier checks, right? One way or another, I got to get 2 checks from you. Once the buyer's agent has it, they're going to deliver the due diligence to the listing agent. The listing agent will sign, acknowledge, and receipt. And then the listing agent delivers it to the seller, who signs and acknowledges receipt. So it's changed hands from the buyer's agent to the listing agent, from the listing agent to the seller, and they sign it once they received. Can we all agree that in your hand and on its way are 2 totally different things? There have been cases where agents have signed for this that didn't have it, because maybe the buyer's agent said, I'll bring it by this afternoon after lunch. Oh, well, I'll leave the signed copy at the front desk. You can pick that up. And then something happens and they never delivered it. Don't sign for it until you have it in your hand. Does that make sense? Because if you sign, acknowledge, and receipt, and it goes missing, who are they calling? They're calling you. Then we have the earnest money. Once the buyer's agent, we meet our buyer, get 2 checks. 1 check goes to the listing agent to deliver to the seller. The other one, I'm going to deliver straight to the escrow agent. Again, may that be the real estate firm, may that be the closing attorney. Either way, once the escrow agent receives it, they're going to sign, acknowledge, and receipt of initial earnest money. If we have any additional earnest money, there's a place there. And you'll remember, additional earnest money is a time is of the essence. So not only do we have the date for additional earnest money that we received it, we also have the time to make sure that it was delivered within that time is of the essence time. And that, ladies and gentlemen, is our 17-page offer to purchase and contract. I'm going to buy your house. Sounds easy, right? Legality, it takes me 17 pages to say that. Revisions to the contract happen on the regular. July is a good time to update. Do they update every July? They don't update for the sake of updating. They only update when there's a need. If there's a rule change, if there's a law change, if there's a policy change, they have to update the contract to stay current. You can always expect changes. I bought my little condo in 2006. What am I, 18 years now, give or take? 18 years ago, the offer to purchase and contract was 8 pages. Fast forward to today, we're at 17. Where are we going to be tomorrow? Where are we going to be July of 2026? We might be looking at 18. We need to, as brokers, we need to make it a point. We've already talked about the importance of being familiar with this. So we need, once we get familiar, we need to make it a point to review the offer to purchase and contract periodically. Because the only thing I do is fill in the blanks. And once we get past the first page, you guys will notice there's not a heck of a lot of blanks in here. My role in completing the contract is very small. And I think what happens sometimes is we get busy and we just focus on the blanks and we forget about everything else. So you need to make it a point as part of your career to sit down and read this thing occasionally. I think a good rule of thumb is at least once a year when they update the form. That's what I used to do before I started teaching this stuff. I do the offer to purchase and contract now about 8 times a year, so I'm good. But before I started teaching this stuff, I made it a point when they updated the form, that's when I sat down and read it, because it kept the rest of the contract fresh. It kept the rest of the information current, and I was better equipped to answer the question, what does the contract say? Be familiar with it, stay familiar with it. Don't do a deep dive until post, but those terms that we talked about, what were those pages? 292 to 304. Start small, work your way up. What questions do I have or comments? Thoughts? It's a lot, isn't it? Remember, you're eating an elephant, one bite at a time. Okay. As we mentioned, NCAR has also provided some commonly used addenda. So we're not going over all of them. There's hundreds of forms. We're not going all over them, but we do need to have a conversation about some of the more frequently used forms, some of the more commonly used addenda. Remember, when you see the word addenda, see the word add. An addenda adds to and becomes part of the offer, and upon acceptance, the contract. It is part of the offer and the contract. Addenda sometimes have conflicting information than what is in the contract. And that's what we're doing. We're taking this information and we're making a little tweak, making a little change. So whenever there's a conflict between the addenda and the contract, the addendum is going to control. The addenda is going to prevail. That's what it's doing. It's adding to maybe creating something different. Our commonly used addenda are also provided by North Carolina Association of Realtors and the North Carolina Bar Association. Same thing with Standard Form 2T. Again, the Real Estate Commission does not provide us with the forms. That's a North Carolina Association of Realtor thing. So some commonly used addenda, I'm back on page 305. If you get a test question about these addendum, more than likely what you're going to get is a scenario, and then it's going to ask you which addenda applies. Which one would you attach to your contract? So we're not, again, not doing a deep dive, just introducing you to these commonly used addenda and when you might use them in various situations. So the first one we're going to talk about is a little early, I know, but when we get into our financing units, we're going to talk about FHA loans and VA loans. And if your buyer is getting an FHA or a VA loan, then we're going to use the FHA VA financing addendum. And the biggest part of this form is it protects the buyer's earnest money if the property doesn't appraise. The lender will only issue the loan on the appraised amount or the purchase price, whichever one is less. So if the property doesn't appraise for the amount that we're under contract for, we're only getting loan amount for the appraisal amount. And in which case, if the buyer, we'll talk about what happens. That's all coming, I promise. We'll talk about what happens, but it might be that the buyer doesn't have the difference in cash. We can't close that gap, which means we don't have loan approval, which means we can't close. When we use the FHA VA financing addendum, we find out that it didn't appraise and the buyer's not going to get loan approval and they choose to terminate, even outside of due diligence, the buyer will get their earnest money back. So we're going to protect them there. The other piece of this, the Veterans United, the VA loan, there are certain inspections that the VA will require the veteran buyer to have. So for example, the VA requires the buyer to have a pest inspection. If it's on an on-site septic system, they'll have to get a septic inspection. If it's on a well, they'll have to get a water inspection. There are certain inspections under the VA that are required. Here's the kicker. The VA won't let the buyer pay for it sometimes. So if the buyer's not paying for these inspections, who is? The seller. Listing agents, is that important that your seller knows that when they're considering this offer? Absolutely. And that's what the second piece of this addenda is addressing. There may be certain inspections that the VA requires. They may not let the buyer pay for those. So FHA VA financing addendum. We're on FHA VA appraisal. All that's coming in 14 and 15. Another commonly used addendum, and I kind of lump these together because they're the same purpose, they're just a little different. Buyer possession before closing or a seller possession after closing. These are not leases, but they are agreements to either let the buyer move in before the deed changes hands or let the seller stay after the deed changes hands. Buyer possession before, seller possession after. And with these forms, they're, again, short term. We're talking like a couple of days. If you're looking at a couple of weeks or a month, then we need to use a lease, because these aren't the full-blown terms of the lease. They just cover very minor things just to get us through these couple days. And the big part about these forms, the big thing to understand is about insurance. With either one of these situations, one party is acting as the landlord, whomever's deed it is right now is the landlord. The other party is the tenant. The landlord has to have homeowner's insurance. The tenant has to have renter's insurance. We need to make sure, and that's a big part of both of these forms, is making sure both parties are adequately insured. Other things that these forms address, there's got to be rent. Even if there's a couple of days, you're living in my house for a day. Yeah, I want rent. It's completely negotiable. Are pets allowed? Who's responsible for utilities and lawn maintenance and all that. So these forms hash all that out. And again, it's short-term use only. I'd say short-term use. They don't give us a good definition of that, but I'd say short-term use is a week, 2 at the max. If you're going more than 2 in this situation, then we need to draft up a lease. So buyer possession before, seller possession after. Another commonly used addenda. Who names these things? The lead-based paint or lead-based paint hazard addenda. That's the name of it. We just call it the lead-based paint addenda. Actually, we call it the LPB, but lead-based paint or lead-based paint hazard addendum. We talked about this back in Unit 20. This is required on all residential properties, anything built prior to, and I've already quizzed this, so you guys are good. I know you know. Anything built prior to 1978. There's a for sale lead-based paint addendum. There's a for lease lead-based paint addendum. Remember, lead-based or lead poisoning affects children. So buyers and tenants both come with children. So we have to cover, help educate the buyers and the tenants about the possible dangers of lead in the home. Another commonly used addendum, and I'm going to go as far as to say probably the most commonly used addendum, is our additional provisions addendum. These are provisions that are popular, they're common, but they're just not common enough yet to make it to the offer to purchase and contract. Might they one day? We'll see. But for right now, they're there and they're used on the regular, but not often enough to make it to the offer to purchase and contract. Things mentioned in the additional provisions addendum. We said earlier that the offeror can put an expiration date on their offer. How can you put an expiration date on your offer? You can use the additional provisions addendum. This offer is good until 5 p.m. on April 19th. If we don't have acceptance by then, the offer is terminated. If there is a septic tank, an on-site septic tank on the property, or if we are considering putting an on-site septic tank on the property, there's a provision in here that covers that. Are there permits? Are we going to have this inspected? We saw the additional provisions addendum in our contract when we were talking about sale with existing lease. So if the property is being sold with an existing lease, the buyer is going to buy honoring that existing lease, in which case the seller needs to provide the buyer some information about history of the tenant, rental income, a copy of the lease. If there's a tenant in place, the buyer buys, this is an assignment. All the terms of the lease stay the same. The only thing that changes in this case would be the name of the landlord. I got a whole unit dedicated to the landlord and tenant. So we're going to talk about that relationship in Unit 11. We're going to talk about the broker's responsibility for those landlord-tenant situations. The property manager is Unit 12. If there's any agreed upon repairs that the buyer is asking the seller to do at the time of contract formation, I can see something in this house is broke, and I want it fixed. I don't need a home inspector to come in here and tell me that this is broke, but I know I want this fixed. So when I'm presenting the offer, in addition, I'm going to include the additional provisions addendum, and I'm going to request the seller to fix it. This way, the seller has that to take into consideration when they're considering the whole offer. This doesn't negate us doing our inspections once we're under contract. We can always ask for more repairs after we have those inspections. None of that changes. We're just asking for something up front. A trigger term or a red flag for agreed upon repairs. If you're with this buyer in this home and they say something like, I'm not buying this house if this isn't fixed, that's our little red flag to use as agreed upon repairs. We need to make sure that the seller will address that. And if they say no, no contract has been formed. Remember, the seller's receiving the offer to fix this, and they have three choices. They can accept it, they can reject it, or we can always counter. It's part of the contract negotiations when it's used in the additional provisions addendum. If there's a manufactured or a mobile home on the property, additional provisions addendum, is it personal property or real property? What's the VIN number? Do we have the title at the DMV? What is the information about the manufactured mobile home on the property? And then if there's an outdoor pool or spa, and we're going under contract in the middle of winter, we may need to address having the pool unwinterized so it can be inspected. We may need to address having the spa set up so it can be inspected. Does that make sense? If you're buying my house with a pool in February, now you buy my house in August, the pool should be up and running and you should be able to have it inspected. So this is specifically addressing that off period, but who's responsible for costs and all that, again, spelled out in the additional provisions addendum. It's a good form. It's a great form. Bet you never heard those two words together, have you? Great form. They do exist. Questions on this one? Another commonly used addendum is their Owners Association disclosure addendum. If the RPODS is exempt, the Residential Property Owners Association disclosure statement is exempt, but the property is in an HOA, then we're going to use the Owners Association disclosure addendum to get that information about the HOA to the buyer. The number one reason why the RPODS would be exempt is new construction, or if I may word that differently, never before lived in dwelling. So if you're buying a new construction, you're not going to see an RPODS. Nobody's lived there. Nobody can attest to the conditions of the home. However, if that property's in an HOA, you still need to know about the Owners Association. And that's what this form is for. Possibly another commonly used addendum, depending on where you are in the state, is our vacation rental addenda. If you are selling or buying a vacation property used solely for vacation rentals, then we will include the vacation rental addendum. Winston-Salem's lovely, y'all, but people are not vacationing here. We're vacationing around mountains or water, right? We're going down to the coast, maybe up to the down to the lake, up to the mountains. I'm not saying you don't deal with vacation rentals in Winston. I'm sure there's one out there somewhere. But what I am saying is when you get to vacation areas such as the beach, the mountains, you're going to be dealing more with vacation rentals. The biggest thing about this, the Vacation Rental Act, the buyer buys this vacation property and they have to honor the reservations on the books for the next 180 days. So that beach house, we got reservations through the summer, right? I'm sure that beach house is already booked by now. If you buy that beach house today, you got to honor those vacation rentals, those reservations, 180 days, 6 months. After that, you can cancel them after that. If you're using it as a vacation property and there's reservations on the books, then you got some bookings there already. But if you're going to use it for personal, your buyer needs to know that they got that 180 days. We see this a little bit more in a future unit, but not much more. Other commonly used addenda is the short sale addendum. We're going to talk about short sales in our financing units. The short and sweet of a short sale is that the owner is underwater. And what I mean by that is they owe more than what we can sell their house for. Short sale is like the step before foreclosure. For the owner, doing a short sale is better than going through foreclosure. We'll talk about the differences in the two. If the property is a short sale, though, I promise we will talk about it. If the property is a short sale is a material fact, which means we got to disclose that it's a short sale potential. If we don't get approval from the lenders to do a short sale and the buyer, we have to terminate. This form protects the buyer's earnest money. This form protects the buyer's due diligence. This form creates a contingency for the seller. And that contingency says, if I don't get short sale approval, I can't sell my home. So if we don't get short sale approval, the seller doesn't have an obligation to sell. They're off the hook. And this form addresses what happens to the monies. I try really hard in the financing units to look at this form because it's a good one. And it does a really good job of defining it, explaining it, spelling it out. So when we get to this in unit 14 or 15, we're going to try really hard to look at this. If not, I'll at least provide it to you so you can. But definitely more on short sales. I ask now you just kind of hang on to it, tuck it in the back of your brain somewhere, and we'll definitely address it later. The last commonly used addenda, and again, depending on the market, it just depends on when we might use this one, is a backup contract. We're going to include this when the property we're making the offer on is already under contract. So the seller is in a legally binding contract. Another buyer comes up and wants to make an offer. We negotiate the terms of this offer like we always do. What's the agreed upon purchase price and due diligence and earnest money? Upon acceptance, this form puts the buyer in a backup position. And what this says is if our primary terminates for any reason, you're up, you're in, and your contract becomes in effect when that terminates. If that terminates. If it doesn't terminate, the backup buyer never moves to primary. The backup buyer has the right to terminate at any time prior to becoming the primary. They won't lose any money until they are the primary. We're going to put earnest money in an escrow account, just showing that good faith. They're not going to pay due diligence until and if they become the primary. All we're doing is putting them in a backup position. We're positioning them so if this contract doesn't work out, you are up. A common question I get is how many backups can we have? And this form only allows one backup buyer. It's not like we can line them up. You can't have a backup to the backup and a backup to the backup to the backup, right? You can't line them up. We have one backup. If you want to be a backup to the backup, call an attorney. I don't have a form for that. Does the first buyer need to know that the seller has a backup buyer? Nope. And again, we're going to negotiate all the terms, But the buyer doesn't know due diligence until they become the primary. The buyer will get their earnest money back only if they don't terminate after the due diligence period. All the terms still apply. We're just legally putting them in a backup position. The last thing we're going to say today, this wraps up our forms in Unit 10, so this is good. Everybody say, yay, it's a big forms day, I know. There are so many forms out there, you guys, hundreds of forms. In your career, you'll never see them all, but you'll know the ones that you use, the most common. We have forms to negotiate repair requests. We have forms to aid in our negotiations. I have a form called a response. For example, response to the buyer's offer. So I have a form that the seller can use to respond to the buyer's offer. And then we have termination forms, termination with release of earnest money, termination without release of earnest money. There's a handful of termination forms depending on the situation. Always remember, if you don't have a form to fit your situation, we got to get attorneys involved. Real quick, any questions? If you do, feel free to reach out to me. Next week, we're going to finish Unit 10. We're on page 307, submitting offers, handling offers. We're going to talk about those alternate land conveyances. That's going to get us through Unit 10. Also on Tuesday, we're going to talk about your application for your state exam. So we're going to talk about how and where you apply. Some of you may be ready to apply. Some of you may want to wait until you pass my class. I need to give everybody the option. Remember, I'm a fact finder. I'm not telling y'all what to do. I'm giving you those options. So we're going to talk about that process on Tuesday, how you can apply for your state exam, for your license. The midterm link will be released. I got it scheduled to be live Tuesday at 1 p.m. So I will show you on Tuesday where you can access that link. And I'm going to leave the link open for a week. So I got it available for you for 1 p.m. on Tuesday till 11:59 p.m. on the following Monday. So we'll talk about what that means. Remember, you guys, to be eligible for the end of class exam, you have to attempt the midterm. I'm not looking for pass or fail. I'm looking to see that you tried. So we will talk about that. We'll have that available. Once we finish 10, application, midterm, then we get going in units 14 and 15. Please, please, please look ahead at 14 and 15. Students struggle. And I'll tell you why. In units 14 and 15, we're going to take our brokers' hats off and we're going to put on lenders' hats. And I have a feeling when you guys signed up for this class, you didn't know you were going to be wearing a lender's hat. We got to switch gears. We got to have an understanding of that lending process. So come be prepared to start financing. I really encourage you guys to look ahead at those units. How many questions in the midterm? 56, 54, 56, somewhere in there? Can we just say 55? Would that be a good round number? Can I take the exam while I'm out of state? Yes, we will talk about that. Is the midterm. Y'all don't worry about one. Don't worry about unit 1. If it's testable, we're talking about it in a future unit. So let's say the midterm is units 2 through 10 and 20. Don't forget our environmental unit. Y'all remember that super scary unit? So 2 through 10 and 20. I'm done. Thank you guys for your time. Have a good weekend. If I can answer any questions, I'm hearing from some of you guys and I love it. Let me hear from the rest of you. Let me know how I can help. That's why I'm here. I'm a tool. You guys have a great weekend. We'll see you Tuesday morning.